For pronouncement of judgment, item number 1.
In view of the aforesaid discussions, this court is of the considered view that in the instant case in hand, the plenary power under section 528 of BNSS cannot be exercised to quash the criminal proceeding, that is so and so, pending before so and so, on the basis of the aforesaid two mutual settlement agreements dated 9/6/2023 and 12/8/2025 respectively. Entered is rejected.
Any mention?
Yeah, my lord.
Yes.
My lord, I would like to mention a matter for tomorrow, my lord.
Tomorrow it will be difficult.
My lord is bail matter, which was listed on 2nd of this month, but due to some problem, this matter could not be taken up, my lord.
Tomorrow is the division bench. Tomorrow is Thursday.
Yes, my lord. If type permits, my lord, it's a bail matter, my lord. Because the counsel for the appellant is coming from the Guwahati also, so he has asked me for the same. But we have informed him also.
So we don't have a single bench tomorrow. Usually, Thursdays there is division bench. Okay, we'll allow, we'll let them. We'll sit in a single bench for some time if required.
Yeah, my lord. I beg to mention item number 8, my lord.
Item number 8, yes.
Yes, my lord, I am for the respondent. I have taken the consent of petitioner. So this matter may be fixed after 2 weeks, my lord.
These were orders for what?
Yes, for filing of reply, affidavit.
Filing of affidavit. Okay.
Yes.
Heard Mr.
T. Taggu.
The learned counsel appearing for the respondent
Yes.
praise with the consent of the other side that the matter may be listed after 2 weeks to enable him to file an affidavit
Yes.
affidavit in opposition in the instant case also. Let the matter be listed after 2 weeks on a date to be fixed by the registry.
Much obliged.
I beg to mention item number 23.
Huh?
Item number 23.
20?
3. 2, 3.
Yes.
My lord, I have having some difficulties, so matter may be taken.
You are preparing for?
I am for the respondent one.
You have spoken to the other side?
Yes, ma'am.
Okay, Mr. So and so, the learned counsel, appearing for the petitioner, praise with the consent of the other side. Praise, comma, with the consent of the other side, that the matter may be listed after
3 weeks, ma'am.
after 3 weeks. Prayer is allowed. Let the matter be fixed after 3 weeks.
After.
My lord, with the consent of other parties, I beg to mention item number 25 on the behalf of G. Tarak, counsel for the amicus curiae. And the matter may be
Mr. So and so, SB, Mr.
matter may be listed after 2 weeks.
Mr. So and so, the London counsel, appearing on behalf of SB Darang, the legal aid counsel, submits that the matter may be listed after 3 weeks. Mr. He submits that he has already taken consent of the counsel for the petition for the appellant. Full stop. Let the matter be listed after 3 weeks.
Much.
May it please your lordship, I beg to mention item number 24. I appear for the appellant on behalf of the learned counsel, Mr. O. Modi. He is out of station. So
the MS so and so, the learned counsel, appearing on behalf of Mr. O. Modi, the learned counsel, conducting the case, submits that Mr. O. Modi is out of station and therefore prays for some accommodation. Let the matter be listed
after 4 weeks on 9th of or 7th of April.
After 4 weeks, we can't fix a date. Let the matter be fixed after after 4 weeks.
Consent has already been taken from the other party.
You write that. With the consent, you write. Okay.
Item number 2,
Much obliged.
May I please, my lord? My lord, this is a pre-bail application, my lord. In
Hmm?
connection, pre-bail application, my lord.
Yes.
In connection with an Nahalagan PS case number 2026, my lord. My lord, a complaint was lodged on 23/12/2026
Hmm.
by a branch manager at Axis Bank, Nahalagan, my lord. However, the FIR was registered on 20/02/2026 after 2 months, my lord, after delay of 2 months, my lord. But may I take my lord to the complaint, my lord? My lord, complaint is at page number 17, my lord. May I read, my lord?
Yes.
My lord, I will read from the last second paragraph, my lord. The top portion are details of the banks, my lord. Case details in brief. The borrower Mili Jajo availed a personal loan from Axis Bank in June 2023 of rupees 11,62,000. The loan was sanctioned as per the policy and product of the bank. An alert was received from ICICI Bank that they are investigating suspected personal loan borrower in the name of Mili Jajo, who died and availed personal loan from them with his KYC, and they came to know that the said customer is also having relationship with Axis Bank. The borrower informed at the time of loan application that he was salaried by profession. He mentioned his employer's name as Director of Higher and Technical Education. The bank checked the salary slip and found fake as no such employee working in Director of Higher and Technical Education, and the IDBI bank statement, salaries credit proof, found manipulated statement as the salary credit narration were manipulated and as shown salary bulk posting, whereas originally amount was UPI fund transfer from Mili Mami. Field verification was initiated at the residential address of Mili Jajo. The team found that the borrower had passed away in 2021. Further, it was found that Mr. Mili Mamik is the actual beneficiary of the loan amount disbursed in Mr. Mili Jajo's name. It was evident that the personal loan disbursed amount proceeded to the borrower's Mili Jajo Axis Bank account number so and so, out of which fund was routed to Mr. Mili Mamik, SBI bank account, and out of which 70,000 was transferred to the Axis Bank staff, Mr. Aditya Hajariga. Further, it was observed that there was multiple transaction fund transfer to the staff, Mr. Aditya Hajariga, SBI account number so and so from PL borrower
So
customer.
there are some serious allegations against you.
My lord, my lord, since my lord, the entire allegation is the sanction of the personal loan.
Not only sanction. I mean, the money has been transferred to your account that has been found.
Yes, yes, that is in many respect, my lord. But
Why the money has gone to your account, personal
that
account?
that Mili Mamik, not from the Mili Jajo, my lord.
Hmm.
Not from the Mili Jajo who has availed the loan.
Hmm.
From Mili Mamik, it was transferred.
So
And my lord,
the
that Mili Jajo,
died in 2000.
no, my lord, that is incorrect, my lord, because that
When did he die?
the death certificate issued by the municipal authority
Hmm.
clearly shows that he died on 2024. My lord, I've annexed the death certificate. That is at page number 21, my lord. My lord, here it clearly shows that he died on 16/2/2024, my lord. After the loan sanction, he was expired, my lord. And my lord, here, when the time of the loan sanction, I was not posted yet. I was posted at SEPA, my lord. And the loan was sanctioned from Doimuk branch, my lord. And there is no such connection, my lord. Now, my lord, I am
Yes, Mr. Louis.
Lordship, since there is a money trail, Lordship, the CD may be called for, or that apart, Lordship.
So we'll call for the CD. Let's.
my lord, I prayed for interim, my lord, because my lord, I am working as branch manager. If I get arrested, I will terminate from the post, my lord.
Okay,
At-
heard, Mr.
That apart, Lordship.
M. Ratan, my lord.
That apart, Lordship, but he is not in his he's partially declared that he has no any pending application before the Supreme Court or any court, but he did not disclose that whether there is any pending any criminal case or not?
No, there is no criminal intention. I have mentioned, my lord. There is no any criminal intention.
As per the notification, lordship, the petition have to mention that whether there is a pending any criminal.
In para 12, I have clearly mentioned that the applicant is a law-abiding citizen and has never involved in any criminal offense, my lord, and has deep root in society, my lord. But my lord, the allegation is, my lord,
Once again.
my lord, in para 12, I have mentioned that he has no criminal offense pending.
But you need to make a statement about Supreme Court also.
My lord, and moreover, my lord, in this case, the punishment, the
We are
offense.
not talking about that merit now. We are
Yeah.
talking about the notification. There is a specific notification issued by Guwahati High Court saying that there has to be a statement that petitioner shall state that whether similar application has or has not been made to the Supreme Court.
No, my lord,
And if made, shall state the result thereof.
my lord, in
So
item,
you'll have to state that there is no, you have not made any step, made any application.
yes, my lord, in item para 19, I have mentioned that the application said there is no pending any other bail application, my lord. I have mentioned that in para 19, my lord.
Yes, yes.
Yes, I have mentioned, my lord.
He has mentioned it,
Oh,
Mr.
you're saying it two separate.
You haven't seen it.
Yes, let's.
And my lord,
In that case, lordship, only city may be called for lordship. Is
You
allegation.
heard Mr.
M. Ratan, my lord.
M.
M. Ratan.
M. Ratan, M. Ratan, the learned counsel, appearing for the accused applicant. Also heard Mr. D. Loy, the learned PP for the state. Then you write, this is an application. Then you write, you write a complaint dated 22/12/2025 was lodged before the Senior Inspector of Police, Naharlagun Police Station, Naharlagun, by one Avijit Sutradhar of Axis Bank Limited, Naharlagun branch. Right, Avijit Sutradhar, BP and branch it of Axis Bank Naharlagun branch, alleging inter alia that one Millie Jaju availed a personal loan from Axis Bank in June 2023 of rupees 11,62,000, and the same was sanctioned as per the policy. Semicolon, that one alert was received from ICICI Bank that they are investigating suspected personal loan in the name of Millie Jaju, who had died and availed personal loan and who had died and availed personal loan from them with his and someone has availed personal loan from them with his KYC. That they came to know that the said customer is also having relationship with the Axis Bank. That on inquiry, it was found that though the aforesaid Millie Jaju claimed to be an employee of Director of Higher and Technical Education and certain salary slips were submitted, comma, they were in fact fake and aforesaid Millie Jaju never worked for Director of Higher and Technical Education. That upon field verification at the residential address of Millie Jaju, the field verification team found that the borrower had in fact passed away in 2021. And it was found actually one Millie Mamik is the actual beneficiary of the aforesaid loan disbursed in the name of Mr. Millie Jaju. That in further investigation, it was found that an amount of rupees 70,000 was transferred to the Axis Bank's staff, namely Mr. Aditya Hazarika, the present accused applicant. Semicolon. It was further observed that multiple transactions of fund transfers to the staff, Mr. Aditya Hazarika's account from the account of Millie Jaju in SBI, in State Bank of India. That it appeared that the source of funds used to foreclose the personal loan account of Millie Jaju was facilitated by branch staff, Mr. Aditya Hazarika, through Mr. Millie Mamik. On receipt of the FIR, in receipt of the complaint, the police registered NLG PS case number 20/2026 under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that Mr. Aditya Hazarika, that is the present accused applicant, is no way linked to any offense that has been alleged to have been committed by him. He submits that the accused applicant was not working in the branch from where the branch that is Doimuk, from where the loan was sanctioned and disbursed. He further submits that he already resigned or he was working.
My lord, he
Submits that in fact, the accused applicant was working in a different branch, namely
slice, my lord. But now, my lord, he is working as a branch manager, my lord.
at that time.
At that time, he was BRO operation head at Axis Bank of SEPA, my lord.
He was working as BRO head in SEPA, and he is no way linked to Doimuk branch. Full stop. He further submits that the aforesaid Millie Jaju, in fact, died in the year 2024 and not not in 2021 as alleged in the FIR. In this connection, he has referred to the death certificate issued by the death certificate of Mr. Millie Jaju issued by the Office of the Commissioner, Itanagar Municipal Corporation, which mentioned his date of death as 16/2/2024. He submits that the accused applicant is presently working for Slice Bank in Dhemaji, Assam. And since he is apprehensive of his arrest in connection with the instant case, he has filed this instant pre-arrest bail application for protection under the same. You write, call for the CD. In the interim, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with NLG case number
2026, my lord.
20/26, he shall be released on bail on furnishing of a bail bond of rupees 30,000 with a surety of like nature to the satisfaction of the arresting authority, subject to the following conditions: that the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order, that the accused applicant shall cooperate with the investigation and shall make himself available as and when called for by the investigating officer, that accused applicant shall not try to, you write that clause, huh? Then you write, interim, this is interim bail. Then you write, let the matter be listed. When?
23, Lordship.
23, listed on 23.
I am the P plus, my lord.
So you have been protected
Yes, my lord.
in interim.
Yes, my lord. I have been developed plus, my lord.
Let's see what comes in this.
Yes, my lord.
Mr. Louis will bring in lot many things against you. Come prepared.
Yes, my lord.
Item number 3. Item number 6 is a bail hearing.
We'll take up the bail hearings, then after that we'll take up. Yes, Mr. Boy.
Yeah, Lordship, here on 17,
So you have been given bail.
yes, interim bail.
Interim
And
bail.
accordingly,
You appeared.
yeah, voluntarily I have appeared before the IO on 1st of March. So
What was the allegation?
allegation here, I have not, I'm no way connection with directly with this instant case, but I have only apprehension. That is, on a mere apprehension, I came before this honorable court. Therefore, my limited prayer is that since the object of this filing the anticipatory bail,
What was the offense actually?
offense, under section 93 or 117 clause 2, 125 clause B, 143 clause 4, 127 clause 4, 146 of BNS 2023 read with section.
How you are connected?
Actually, my wife was actually called for a mere inquiry. Then thereafter she was arrested. This
Minor girl was working with you?
Pardon? The Lordship?
Minor girl was working in your house?
Yes, the girl in possession was with in our possession, no doubt, but it was for giving her a good education and like that. So therefore, my only limited prayer is that since my wife has been was arrested and she was released on bail yesterday. Now, only on mere apprehension, I came before this honor. Otherwise also I have no connection.
No connection means the girl was working in your house. So how can you say it's no connection? The girl was working in your house and girl was found to be assaulted with injuries.
No,
Then
that is different part. Those allegations are different allegations. That there are two minor girls.
Hmm.
First minor girl,
Hmm.
against that, there was an allegation. There are five accused. Five accused.
The two
For-
minor girls were working for whom?
Pardon, Lordship?
Two minor girls were working in whose houses?
One minor girl was with me that voluntarily they have hand over us for looking after, for giving good education.
Who
That's all,
has
nothing
handed-
more than
Who
that.
has handed over?
The accused, one Srimati Rupa Vishwas,
Ah,
who is involved in that, another case.
Hmm.
So I have no connection with that case, this entire FIR.
okay. There was a case wherein one minor child was found to be abused in a different house.
Yes.
And that girl was also given by Rupa Biswas.
Maybe, I do not.
Then, in your house also, a girl was given by Rupa Biswas.
Yes,
She's also a minor girl.
yes.
And you, you have employed a minor girl.
Not employed, only for as a guardianship,
Hmm.
to take care, to give education, that's all.
Okay, where is the bail order?
Bail order is 17th, this bail order passed on 17th February 2026,
No, 17 February.
interim.
No, I'm not talking about interim. I'm talking about your wife's bail order.
Bail order is here, Lordship, kindly bear with. May I read the operative
No, you
portion?
just hand it over to me.
There was something. That page only, Lordship, operative portion.
Yes, Mr.
I, on last occasion, 3D and status was called for.
Now, is there any material against them?
CD was not received because it was sent to the another court, JMFC report. That's why only status reports has sent.
Hmm.
That means investigation almost completed. Accused Sange's ring statement was already recorded. And IO says she has no objection if the level court is pleased to make it absolute.
Right, okay. Then we'll make it absolute.
Yeah.
Because otherwise also the bail has been given to the wife.
Yes.
And it seems that prima facie it was found that the girl was adopted by them, not employed for working or something like that. So, okay, heard Mr. D. Voje, the learned counsel, appearing for the accused applicant. Also heard Mr. G. Tado, the learned additional public prosecutor for the state. This is an application right hand. It is the case, it is submitted that based on the report and a complaint dated 7/2/2026 lodged by the chairman of ICR, Child Welfare Committee, Capital Complex, Itanagar, alleging that on interaction of a child produced at Women Police Station, Itanagar, it was found that the child was brought from the state of Assam and was employed to work as a domestic helper at the residence of one Doke family of F sector, Itanagar, and due to continuous torture, the child ran away. The child ran away on 6/2/2026 at night. It was stated that that aforesaid WPS case was registered accordingly. It is found and it is also stated that in connection of the aforesaid case, one Srimati Doke is stated to have been arrested. Doke is somebody else, right?
That is
That's a
somebody,
different,
I have no
different
connection.
different case. So it stated to have been arrested. Next para you right? Mr. Boje, the learned counsel appearing for the accused applicant submits that the present accused person is nowhere connected with the aforesaid WPS case number 9/2026. He submits that, however, his family has adopted a girl in the year 2018/19 who has been staying with his family as their daughter, and they have been giving education to her. Full stop. However, in connection with the aforesaid WS case number 9/2026, his wife Srimati Jumpi Voze Sering has been also arrested without any materials against him on 13/2/2026, and she was released on bail by an order dated 9/3/2026 by the learned Court of Judicial Magistrate First Class UPA Papumpare District, Arunachal Pradesh. Full stop. Full stop. He further submits that there is no allegation against the accused applicant, and in fact he has been granted interim protection by a coordinate bench of this court on 17/2/2026. Full stop. In terms of the aforesaid order dated 17/2026, the accused applicant has already appeared before the investigating officer and got his statement recorded. Full stop. In view of the aforesaid, he praised that the interim protection so granted by the coordinate bench of this court should be made absolute at this stage. Full stop. Mr. G. Taro, the learned additional PP, has produced a status report of this case, of this instant case, which reveals that investigation in the instant matter has already almost been completed, and he has got an instruction that the investigating officer doesn't have any objection if the interim order so passed earlier on 17/2/2026 is made absolute. Full stop. In view of the aforesaid submissions and the status report that has been submitted before this court is in the considered opinion that the interim order passed on 17/2/2026 by the coordinate bench of this court should be made absolute in same terms and conditions as stated therein. In view of the aforesaid, the instant AB application is disposed of as allowed.
Highly obliged.
Matter number 7.
You need this order? Just give it back to you.
May I please your lordship? Lordship, this 482 application has been filed by the petitioners on apprehension of arrest, lordship. Lordship, in connection with an complaint which has been claimed by the Doimuk police station that has been lodged by one Tessie Tezetera, lordship. Pursuant to an agreement dated, lordship, 8/3/2025, your lordship can find the agreement, lordship, at page number 12, lordship.
What agreement?
Lordship, as per the agreement, lordship, the petitioner was engaged to work in the construction of a building of an
You
officer
wanted
of
to
the
say something?
Doimuk police station, lordship.
One second, you want-
Here again,
Statement is
lordship,
not there.
no, not is that, yes, the statement is not. there,
That, that statement is there or not?
Not there, lordship. Supreme notification, lordship, as I have this petition has been filed accompanied with an lordship affidavit as per the para 3 of the affidavit that this
There
is the
are, which affidavit?
lordship, page number 11.
There are three.
Yes, your lordship. That no bail application is pending before any superior or inferior court or any other court in India.
But how can you make this correction here before Supreme Court by handwriting?
Lordship,
Who has done it?
even in the affidavit, it should be in the plain, lordship.
Hmm?
In the
It is,
application, lordship.
lordship,
The
identical,
affidavit, it is fine.
lordship,
But-
in
but-
paragraph 14 also, it is there, lordship, that no other
No,
bail
no, who
application.
has written this before Supreme Court in by handwriting? You have put it.
But in our,
Maybe it was,
I mean, you cannot do this to it like, you can compare with who has allowed it to do it in the court copy. See, this is a notification,
Yes.
mandatory notification.
Yes.
It has come from the Guwahati High Court.
yes,
How is that this has been written here? Hmm?
even in our affidavit, in our petition, lordship, there is no any handwritten, lordship. Correction to the defective of correction.
You cannot do, I mean, there is no signature here. This is handwriting. Who has put this?
Lordship, sometimes, lordship, the registry, when finds any defects in the file, lordship,
No, it is not defect. It's a statement.
yes.
Mr. Sharma, this is not a defect. This is a statement which is required to be made, and the statement was not there. Then some statement has been, I mean, now it has been corrected by handwriting
Yes, sir.
without any this thing. But this cannot be done. I mean, whoever has done it, I mean, it should not have been done like this.
Yes, sir. I apologize, lordship, for that.
And it should not have been allowed by the registry. What is to be done? You'll have to take it back. You take it back. I mean, you'll have to file it with this.
Yes, lordship.
This cannot be allowed, let that be. Mr. Sharma,
Yes, lordship.
we cannot allow this.
I apologize, lordship.
We cannot allow this. I mean, this will send a wrong signal. It cannot be allowed. This is a mandatory thing. This is something which you have to do mandatorily. And there is no provision of correcting petitions by handwriting these days. Those days have gone.
Yes, lordship.
Earlier it was allowed, but there was a special notification nowadays. If you want to correct something in the body of the application, then you'll have to file an IA.
Yes.
That has to be allowed. Then only you can amend, modify or whatever. This is not allowed.
Yes, lordship.
So you take it back. You take it back and
I may be allowed to file a fresh,
you
lordship.
file it first.
Yes.
I mean, that liberty will be given, but don't do it like this. I mean, this is not good. You are quite a seasoned person. You keep on appearing in Guwahati High Court, but still you are doing this. This should not do. I don't know whether who has done it. I'm not telling you, but it should not be done. Right, heard Mr. B. Sharma, the learned counsel appearing for the accused applicant. He submits that he wishes to withdraw the instant application due to some technical defect, and liberty should be given to him to file a fresh full stop. Prayer is allowed. The matter is dismissed as withdrawn. You file a fresh.
Yes, Your Lordship. Highly blessed, Lordship.
Monthly.
Item number 9 to 12.
All analogous. Yeah, anybody appearing in 9 to 12? FC, I think Mr. Singh was here.
Lordship.
Mr. BK Singh,
Please.
he was here probably. I have seen him. This affidavit in opposition not filed. Have you filed?
No, I'm not opposing.
Hmm?
We are for,
No,
number 4.
you are for whom?
I'm for respondent number 4, civil supply.
Respondent number 4. So you are not opposing the prayer. I mean, this is for what? This is IF for condonation.
Right.
Okay.
Right.
So we'll take it up after some time. Where is Mr. Singh? Somebody was here.
Yeah, man. I will inform him. Like.
Just intimate him. Then they're all the same, right?
Minor, all
All condemnation.
condemnation. Right.
You are not opposing to that.
I'm not opposing, my lord, and
Any other respondents are there?
yes, yes, respondents are there, private respondents are there.
And I mean, the lawyers are appearing for them.
Lawyers, some lawyers are appearing, my lord.
Mr. Singh. I mean, these are all relay condemnation.
One delay condemnation has been left on last occasion.
Mhm.
In other 3 matters, the delay has been condoned.
Condone. Which one is left?
Item number 9.
Item number? Nine,
Application
yes.
number 93 of 2023.
Yes. And who are the respondents?
Respondent was there, Mr. Tony Partin. Because on the last occasion, Mr. Partin was not there, so
Hmm.
delay was not condoned in this case.
Hmm.
Whereas in other matter,
Mr. Tony Patini is appearing for whom?
appearing for the private party, that is respondent number 1. I would just like to place
KCB Enterprise.
KGB Enterprise.
And Mr. You are appearing for all other government respondents.
No, there's a food and civil supply, my lord.
Hmm?
Food and civil supply,
Food and Civil Supplies.
government of Arunachal Pradesh, my lord.
This is respondent number 4.
Yes, 5, my lord, 5 also. That
4
is-
and 5.
Yes, my lord.
4, 5. And what about this 6
6,
and
government.
2, 3 and 6, MSP Pangu was appearing.
But she's not there. Yeah, he says like he doesn't have any objection, but what I know about other people.
In the other cases also, they had no objection. I have given the copy of the last order. First paragraph may kindly be seen. P. Pangu was also there, MSP Pangu.
But the private respondent is not.
Let it be taken up to some time. Alan. He was there, Mr. Partin. I will call him.
And other matters are
And
ready.
Other matters are only review petition. That may be taken after 4 weeks, my lord. Today, this condemnation may be condoned, then all the matters be taken up.
If see like if Mr. Tony Patin is there, then
He is there. I will call him.
he's there.
He's
Just
there.
call him, then like we'll pass it. Then all the matters can be posted for this thing.
Admission.
For time being.
Item number 14.
Lordship, in this matter, Lordship, TCR as well as service report of the respondent.
Okay. None appeared for the petitioner when the matter was called for. However, Mr. D. Louis, the learned PP is present. Office note dated 10/3/2024 reveals TCR in the instant method is yet to be received. Full stop. Registry to send a reminder for the TCR. Full stop. Let the matter be listed after 3 weeks.
Item number 15.
TCR still awaited.
Yes, Lord.
Parties are duly represented. TCR in the instant case is still awaited. Let the matter be listed after 3 weeks.
Blessed.
Item number 16. Fine.
16. 16 could do.
Yeah, no?
I think this matter I have been engaged in this case.
Okay.
This is a matter which is a question. But what I find here
Huh.
that no case has been registered. They have issued a notice under 35(3) of BNSS. 35(3) of BNSS. If your lordship kindly see,
No, it has come for orders now today.
Yes.
Why it has been listed?
city government is there.
For taking instruction.
Huh?
For taking-
1 second. Did you take some time for filing some objections?
No, there's a report from the.
Then why it is listed on in the?
My lord,
the order.
I don't know. I was not there. What I have seen entire petition,
Hmm.
my lord, they have issued a notice under 35(3) BNSS. The legal issue is that 35(3) and 3 BNSS cannot be true on WhatsApp.
Hmm.
Cannot be true on WhatsApp. That's your lordship will kindly see. If your lordship kindly see the WhatsApp message which has been sent at page 17.
Now, what is the offense all about? Is it regarding something to do with 307 or something? 307? I mean, what? It is regarding what?
My lord will kindly see now. If your lordship looks into that notice was sent on 22/10/2025. Electors notice to be treated as notice under 35(3) BNSS at page at page 17. Kindly see at page 17. There is no registration of an FIR. My lord will kindly see there is no registration of an FIR. Is only after a WT message they have sent to us that I have to appear in person to 35(3) of BNSS at page 17, my lord. You are requested, lordship got it?
Yes.
You are requested to so and so Lohit to appear in connection with your inquiry. White so and so GD entry dated 22/10/2025 on or before 25/10/2025 without fail for purpose of inquiry. This may be treated as notice under 35(3) BNSS. Alias accused, please confirm action taken by so and so. Based on a GD entry. How can they do it, my lord? There has to be a registration of an FIR. And there is a standing order of the Supreme Court. Kindly see at page 18. See page 18, my lord.
Yes.
Which at page 19, kindly turn to. Page 19. in pursuance to so and so, Chaitanya Kumar until March. My lord, it has been noticed that the number 2.
So the petition has been filed for quashing of setting aside of that
Yes,
notice.
notice. Let them follow the procedure. Why they are not following? There was an interim order which was passed by this court. And see the judgment of the until, my lord.
Yes, what is your instruction? But I don't know why this matter has been listed in the
Because
order column. It should have been in the admission.
People also wanted it should be on admission, let it be on admission. My lord. Because there is a very short point. I don't know why it is.
This WT message was sent only for inquiry purpose.
How?
He was,
You are asking somebody to be present in the inquiry, right?
yes,
And W2 message, whether you can send it.
it was sent to the OC there, OC at Teju, PS Teju for executions. And he, and the applicant acknowledged himself, thereby
Judgment is shown.
he makes excuse that he is
Just-
ill.
My lord, will
So he
kindly
put on-
see one judgment of the Supreme Court, it will make very clear. See the judgment of until, my lord. Para 23. See para 23, my lord, until judgment. 23 to, yes.
Yes,
See-
until has made it clear.
My lord, what I am saying,
Hmm.
it is a fact that it is a deputy message.
Hmm.
It is a fact to a WhatsApp we have received.
No, it has been sent to the OC. Whether it has been sent to you,
Yes, I came
Where?
to this court.
where?
Kindly see.
Whatever the documents you have given, these are all from the OC.
Yes,
There is no document showing that it has been sent to you. Then in that case, how can you come
I am
filing this
I am-
criminal revision?
One second, my lord. My lord will kindly say para 4, my lord.
The para 4 I have gone
Yes.
through. It only says
Yes.
that this 35(3).
No. That the petitioner was not aware of the content of the complaint laws on 25/10/2025. The
Para
petitioner,
4.
para 4.
The para 4 it says the petitioner begs to say this so and so.
Yes, the petitioner has sent his legal counsel to receive the certified copy of the complaint from Naharlagan police station. However, when legal counsel requested.
No,
for the
Mr. Das,
Yes.
it was not sent to you. It was sent to the
No.
OC. And
Para
OC,
2, kindly see. Para 2.
then where is
that
the document that you
That
have
the
received?
petitioner begs to set. Annexure A, my lord.
Hmm,
That a petitioner begged to state that he received an electronic notice
hmm,
dated 22/10/2025
hmm,
from respondent number 6,
hmm.
purportedly under section 35(3) of BNSS, containing WT message dated 22/10/2025 from officer in charge, Naharlagan police station, so and so, requesting to direct the petitioner in the district. So I have received, my lord. Through WhatsApp I have received. That's my statement. Let them deny that I have not received. As page 17, I have received that.
The 17 is addressed to the OC.
But I have the petition, through WhatsApp it has been sent. Petitioner, he received an electoral notice from permanently under 35(3).
But that you have received in WhatsApp, there is no proof. There
But
is no
that's
document.
what, my lord will kindly see the order that has been passed by this court. So let's see the order that has been passed by this court, my lord.
On the basis of this thing, how can
I
one
understand.
washing can be done, Mr. Das?
So kindly see the order of on 3/11/2025. Lordship got it?
Yes.
So and so and Mao, who is aggrieved by notice on 35(3), requiring him to appear before Naharlagan police in connection with so and so.
Hmm.
The petitioner directed to appear
Hmm.
before the police or not before 25/10 without fail. Learned counsel contend the aforesaid notice under 35 was sent electronic by WT message, and in this condition submitted is contrary to established law in terms of so and so. Had drawn attention para 3, which may be reproduced. This is with this given the petition invoking inherent power seeking questioning of the notice itself, interim pray for staying the proceeding. Learned PP on so and so, submit the said notice was given to the petitioner. Kindly see, at the Mr. So and so learned additional public for the state, on the basis of instruction, submit that the said notice was given to petitioner only for the purpose of preliminary with reference, and therefore the petitioner should not be prejudiced. It is their case there. My lord, it has been given to us. I have perused the material record and consider submission of both the learned counsel before proceeding further, say provision of so and so, police so these are given. I have considered material, case law and submission made by both the learned parties. I find that a categorical mandate of the Honorable Supreme Court in case of so and so, notices sent through WhatsApp and other electronic mode do not suffice for the purpose of 35 criminal petition merits education so and so. No formal notice. In the context, I find merit so and so, impute notice was state. It is their contention. That is what I am making a submission, my lord, here. That instruction of the they have stated on the basis of instruction. Kindly see, my lord. Said notice was given to petitioner only for the purpose of preliminary inquiry. A reference to DG entry. If they want to give it, let them give it in a formal way, my lord, not in this manner.
Case was not registered yet.
Then you
Before registration, it is a part of investigation authority to inquire, preliminary inquiry, whether this person has, there is some merit in the complaint or not.
So are you aware that 35, when and what circumstances 35 notice should be issued?
Yes,
I mean, all inquiry, all this kind of thing, you will issue 35 notice. Can it be done? You see 35,
yes, it cannot be.
then,
I am aware about it.
then how can you
But,
issue 35 notice?
Usual practice here in
What
this is
usual
when,
practice?
when person
Mr.
residing
Tado,
depend.
I mean, you are having a problem with your wife in your home, and with 35 notice will be issued.
He's residing from.
Forget
in
about
other-
that. I mean, I'm asking whether in usual course for, I mean, each and every inquiry, section 35 notice will be issued. Why, what is the purpose of section 35 notice?
When complaint is made,
When police may arrest without warrant,
yes,
what does it mean? Under 35, you can arrest when there is a cognizable offense.
yes.
Issuing, then, I mean, it is only for the purpose that without warrant, you can issue them, arrest them. And only in that circumstance, if you think that the police thinks that there is a necessary need to arrest somebody, then section 35 notice will be issued. Then if you want to do a preliminary inquiry, why are you issuing 35 notice? Can it be done?
No, even police officer instructed me that only you, this is a usual practice they have adopted.
I mean, like, if you do things so casually, you tell your inspector if you do things so casually. I mean, now a lot of things have been changed. We have seen the Supreme Court has already laid down how notice has to be given to the family members, how notice to be given to the accused person. Section 40, 47, 48, 35, all this has to be medically complied with. I mean, if there is a small element of non-compliance, then it will go against the prosecution.
Mato, not only that, there is a judgment of the Karnataka High Court 2024 SCC online.
2000.
Karnataka 2024 SCC online Karnataka 67. This I'll read paragraph 10. It does become mandatory for a notice. Kindly see this, my lord. My lord, kindly see this. I'll just.
You can read out also.
No, kindly see. No, please see 11. Before top of the 11.
Para 10.
Yes, para 10, I have marked that. Yes, marked. Kindly see para 10. Where this before that is yellow.
Yes.
Yes, kindly see, my lord. See, my lord, the case number, everything has to be mentioned. This is 35(3) BNSS, you cannot issue by WhatsApp, but more than then, case number, complain, what is there is not there. And you will call this person, you will put without any number on the basis of some GD entry. I think this is a way, that's why immediately there was an interim order passed by the court.
No,
It is-
no,
let-
this court was only trying to find out whether it was served on him
No, kindly
or
see,
it was.
It is,
was-
my lord, this is the submission that has been made by them itself. It is nothing. They said you want, we have, this is a procedure, this usual procedure in state of Arunachal Pradesh. That cannot go against the law that has been laid down by the Supreme Court.
Yes, yes.
And see the paragraph until my lord judgment. In 2000, I have given that.
Yes.
Paragraph 23, kindly see my lord. Until judgment,
Para 23 years.
23, my lord. 23, please see para 23
Yes.
first. Section 35, 6, 21, 30 for 20 onward, 35, 6, 20 see my lord.
Mm.
35 BNSS provide for arrest of person 20, paragraph 20
Yes, yes.
of the investigating agency ensuring that the concerned person appears before the IO and cooperate with the investigation. Provisions delineates the prerequisite that must be fulfilled before a person can be arrested without a warrant, keeping in mind the laudable objective of safeguarding the liberty of an individual. Legislative intent behind the provision is that of restricting arbitrary arrest. Section 35(3) of BNSS mandates, number paragraph 21, mandate the service of a notice whenever the IA investigating agency on the basis of a reasonable complaint, credible information or suspicion determine that a person may have committed a cognizable offense, but does not deem the arrest of such person necessary. In such a scenario, the investigating agency is mandated to issue a written notice directing the person to appear before it or at such other place as may be specified in the notice. So, my lord, there has to be basis of a reasonable complaint. Where is that? There is no complaint, nothing, no FIR. How can you do it? Now, please see paragraph 38. All this is 22 also same, 22 or 23, 24.
Yes, yes.
If you see paragraph 30, 38, please see para 38, my lord. 38. The contents of the the contention of the applicant, that notice under 35 of BNSS, Lordship got it?
Yes.
2023 falls within the same category as summoned under section 71 of the BNS. And therefore, since the latter allows electronic mode of service, the former must also be permitted to be transmitted electronically, cannot be accepted. Cannot be accepted for the simple reason that a summon under section 71 of the BNSS has no immediate bearing on the liberty of an individual in case of his non-compliance. However, a notice under section 35 of BNSS could have an immediate bearing on the liberty of the individual in case of his non-compliance as laid down under section 35(6) of the BNSS of 2023. So there is a distinction, 71 and 35. So liberty of a person.
So strict compliance is required in section 35 more than.
More than, yes.
Someone's in section.
Yes.
Someone.
And not on the basis of some GD entry. There has to be a complaint, there has to be an FIR. On the basis of that, a notice has to be sent. Personal notice has to be sent, he has to receive. Then thereafter, it will amount to compliance of 35. Otherwise, no compliance of 35(3). Where is that compliance? There is no compliance. And on the basis of a GD entry. You are, now my lord, hypothetically, let us say, now a person has been called, you go there. Now, once you go there on the basis of GD, he said, okay, this is what on a GD entry. Now he will immediately arrest and thereafter complain. It cannot be, my lord. That is why in this paragraph 38 said there is a difference between 71 and 35(3). Once you call to the police station for an inquiry, in when personal liberty is concerned, there is a possibility you may arrest also. So these procedures, with great respect, has not been followed by them. On the face of it, it goes, my lord. On the basis of a judgment that has been laid down by Supreme Court. And Karnataka High Court says there has to be a proper complaint. There has to be an FIR. Then only you can issue 35(3) of BNSS. Where is that? My learned friend is saying that there is a normal practice procedure which is following in the state of Arunachal. That practice cannot continue, my lord.
Yes, yes.
This is my case, my lord. Let them do it properly, my lord, not in this way, my lord. A very narrow campus, my lord. They have not followed the procedure laid down and under 35(3) and followed by judgment of the Supreme Court. That is 25, that is until judgment. And it is admitted by them also. But otherwise, there has to be an FIR, there has to be a complaint. Where is that?
Report from IO, it reveals that there was money lending. This applicant borrowed some 1 crore amount in presence of 2 witnesses, and they lodged an FIR, but it was not registered. Only GD entry.
Why? I am telling, I am giving a quick answer, my
And
lord.
for that purpose only, for preliminary purpose, inquiry purpose only, he was intimated and sent this notice. But yes, of
Mr.
course,
Sado,
of
I mean,
course,
just for the sake of making submission, please don't make submissions.
of course,
See, I mean,
last line.
already the provisions have been read
yes,
out
yes,
by the learned senior counsel. And you are aware of the, I mean, settled law. Then you have already stated that that is the, I mean, some kind of procedure they are following so casually. They're following this procedure. In spite of that, if you try to defend your,
no, I'm not defending it. Them.
then there is no point.
I'm
making
only
a-
point out the fact of
No,
what is
the
there in
fact, no fact that you're not, those are not fact. You are saying that like they are saying so. That's why you're submitting. I mean, are you defending?
No, I'm only reading their reports before this
I
court.
mean, some reports only because the IO has sent it to you. Are you going to read all those reports? Because those reports doesn't carry any value. In fact, you should tell your IO that these reports don't send this kind of reports.
Yes, your lord.
You have, I mean, since some statutory provision has been violated by the IO, that if he wants to justify that I want to do this, that, I mean, whether that will buy anything. You can't buy anything out of that. You have to have some resources, good value to buy some certain things.
I think what my learned friend is saying, all the instruction that have been received by IO, maybe some private dispute between two parties, some amount has been paid, has to be paid. So in a very shortcut method, a GD he knows that an FIR cannot be lodged, a complaint cannot be lodged. If it is lodged, it will be area of a civil dispute. So where is the question or the criminal?
So they want to basically bring those people there.
Yes,
like a
correct.
compromise.
Yes, correct.
That is what they're. that is what
Absolutely,
they do.
that's what they want to do it. But they, my lord, if they want to bring it very well, you bring it, but file a FIR, file a complaint, serve a notice 35(3) properly as per judgment of the Supreme Court. Standing orders are there of the Supreme Court. My lord, your lordship knows 41A now, which was earlier, less than 7 years also, then it has been circulated. I know when it was moved before the Honorable High Court, is somewhere before Chief Justice also, I said that these are not being followed. He said, no, this has been circulated to all the courts, district court also. Supreme Court has given direction to circulate to all district court. And 35(3), we have a standing order is there. So please follow that procedure. State has to follow this procedure. That is my respectful submission, my lord. This should go.
I've written to IO concern or CSP and even DJP also in this regard. But
Nothing has come
they
to it.
said, there is no any such, they could not find any
He's
such.
trying.
See, I mean, now matter was listed in order, but since both of you are agreeing and he has already argued that I will dispose it of, okay?
Yes,
There
it
is no
can-
problem.
It can be.
I'm with
Because otherwise there is no issue. I don't know why it was placed in order, but anyways, I mean, since
Already stays there also there.
Yes, I think he's trying, but nobody is listening to him. He said that may not be possible, he said.
Hmm?
35(3) BNSS,
Ah,
I think he also
no, he is also
instructed.
aware, he is also convinced.
Yeah, he
He
consulted.
is also aware.
He is aware what he
He's a
can do
learned
it.
person. yeah.
But
He knows that
Sometimes,
it cannot be issued, but still they are by procedure
Yes,
they are
yes.
using.
police department and we prosecutions are on different.
Correct. I mean,
So,
yeah, I mean, they will
sometimes
be
we are
aware,
not
but-
so connected.
Anyway, then I'll close it.
Yes,
I'll-
yes, it can be
I'll
disposed.
pass the judgment, I mean,
yes.
whenever, as soon as possible.
Yes,
If
yes.
possible
My-
today, I'll do it.
No, it's okay. My Karnataka judgment also, we'll get a copy. Karnataka judgment 2024, paragraph 23.
Yes.
Did you?
Paragraph
Paragraph
10.
23, in Karnataka, para 10, para 10,
Paragraph 10.
para 10. We'll supply a copy during the
No,
course.
yes.
Their judgment also may be a bit of helpful.
Salam, you right. Heard Mr. D. Das, learned senior counsel, assisted by Mr. I. Das
And my friend is there.
and me,
Yes, ma'am.
Smo, the learned counsels appearing on behalf of the petitioner. Also heard Mr. G. Tado, the learned APP for the state. Though the matter was listed in the order column on agreement of the parties, the matter has been taken up for disposal. Hearing concluded. You don't write anything. I mean, if possible, I'll pass it on today or pass it today.
Yeah.
Then I will not reserve it. And if
Yeah.
it goes, then I will reserve it.
There's an
So,
interim order that will continue.
Interim order, so first I'll continue. Then I'll
Yes, yes,
I'll pass the order if you would let.
yes.
Now, if possible, I'll dispose it of
Yes.
today only. So
And
that's
I-
why I'm not writing it.
Just
that-
handing over the judgment of the Karnataka also.
Yes.
That one. There are other judgments which I
If-
don't want
if
to.
possible, do it today only, so don't reserve it. Or if not possible, then.
Because there are other judgments I don't want to show.
No, that's fine. I
35(3)
mean,
until judgment is
until
a-
judgment is very clear.
Is the main.
I don't think this one.
Deeply obliged.
Obliged. Item number 9 to 12, it's a password matter.
Please submit.
Yes, madam, you are appearing. I mean, who is appearing for the private respondent?
Private respondent.
My lord,
You are
I'm sorry, I
appealing?
was in the other court.
You have any objection to this?
No objection, ma'am.
No objection,
Yes.
right. In I number 93. Heard Mr. B.K. Singh, the learned counsel appearing for the petitioner. Also heard Mr.
HK Jammu, my lord.
S.A. Jamo for respondent number 1.
Yes.
Respondent number 1.
Yeah.
And
Item number 9, I am respondent number.
item number 9 only. Then MS.
I'm for the state, Your Lordship, P. Pangu.
Says for the state for respondent number
456, Your Lordship.
4, 5,
456 is for civil supply.
civil supplies.
No.
You will be number 6 and
Deputy
3 and 6. No.
2 and 6.
2 and 6. No, 2 is Government of India.
DC.
Government of India, anybody is
Yes,
appearing.
my lord.
You are appearing for Government of India.
No, Your Lordship.
She is
Gov-
appearing. She can
Government-
appear only
government
for
of Arunachal.
only for 6.
6.
6, Your Lordship.
And civil supplies you are appearing.
Yes.
4, 5. Mr. So and so for 4 and 5. But none appears for the. But your Mr. Singh, your grievance is against whom? Mainly.
Against the 1.
Hmm?
Respondent number 1.
This one number 1. And involvement of Government of India is not there.
Because they were made party in the suit, civil suit, my lord.
Otherwise, they don't have
We
any
filed
role.
a transfer petition for transferring of the civil suit from Tawang to the UPR. And that was,
And notice was issued when earlier.
notice was issued way back in the year 2023,
23.
23.
Okay, no one is appearing for the union.
Sometimes they appear, sometimes they disappears.
Okay. And none appeared for respondent number 2 and 3. right?
Yes.
Respond number 2 and 3, full stop. This is an application. Notice in the instant application was issued on 5/10. On 31/5/2023, right?
My lord.
Notice was issued in the instant application on 31/5/2023. However, no objection has been filed by any of the parties, any of the respondents in the instant IA till date. The learned counsel appearing for the respondent number 1 as well as respondent number 4, 5, and 6 have stated that they don't have any objection if this court condones the delay of
52 days.
52 days in filing of
93.
filing of the CRP or the filing of the review
Review
petition,
petition.
connected review petition. Full stop. This court has also gone through
Paragraph 2 to 8.
paragraph 2 to 8, wherein the delay has been explained by the applicant in the instant case, being convinced with the explanation that has been given in the aforesaid paragraphs, as well as on the basis of the submission that the respondents do not have any objection in condoning the instant petition for condemnation of delay. The delay is condoned, accordingly the delay is condoned, and the IA is disposed of. Let the connected matter be listed, like a connected review petition be listed after 4 weeks. And all other matters also 9 to 12.
9, 11, 10, 11, 12.
10, 11, 12 also, you fix it after 4 weeks. Huh? Same order. Now, same order means this condonation order will not be there. Condonation only in this matter, item number 9. Others listed after 4 weeks, along with these matters.
Obliged.
These are all
Right.
analogous matters.
Item number 13.
तो 12 बजे इस समय का नहीं तो 12 बजे पर फिल्म को
My lordship, TCR were called for on the last occasion, my lordship. TCR was called for.
Okay, parties duly represented. TCR in the instant matter is yet to be received. Let the matter be listed after 3 weeks.
Your lordship, after 1 week in this JMFC UPI only, your lordship.
Okay, after 2 weeks. After 2 weeks. I'll just come back in 5 minutes.
Item number 17.
Lordship, in this matter, service has been completed on behalf of respondent. And the LCR has also been.
So we'll place it for admission hearing. Yes.
Yes. Lordship, since the respondent is not engaging any advocate and the matter being a POXO case.
POXO matter.
Yes. Amicus query may kindly be appointed by Lordship.
When was it received? It's a service.
3 February 26.
Okay. Heard Mr. So-and-so, the council appearing for the petitioner, also heard Mr. D. Lohi, the runner AVP for the one PP for the state. The office notes dated 3/2/2026 as well as 9/2/2026 reveal that service on respondent number 2 has already been completed and TCR has already been received. However, it is seen, however, none appeared for respondent number 2 when the matter was called for. In view of the opposite, this court in view of the considered opinion that an legal aid counsel amicus,
Legal.
amicus,
Lordship, amicus lordship. Yes.
and an amicus curiae should be appointed to represent respondent number 2 in the instant case accordingly. Accordingly, MS Jaya Dojit, advocate is appointed as amicus curiae to assist the court on behalf of respondent number 2. Full stop. Let the matter be listed for admission
Lordship,
after 2 weeks.
Lordship, on 25, as the leading counsel is coming from outstation, 25 of this month.
Possible. Let the matter be listed on 25th of March. But you'll have to serve the copy and, okay, well, let the matter be listed on 25th March as paid for by the parties. A copy of the instant petition to be served on the amicus curiae within a period of 2 days.
I will personally inform her, Lordship. I will highly oblige.
Item number 18.
Anybody is appearing?
Lordship, it is listed for mediation.
Hmm.
In the last, in this matter, in the previous hearing also, the matter was listed for, but for mediation, but the opposite party could not be able to make themselves present. But if Lordship puts this case for mediation, we are ready to accept again.
But other party is
Considering
not
the
there.
other party appears.
We'll wait for the other party. But mediation has to be, I mean, otherwise it will not fulfill any purpose. If you put it and the other party is not agreeable to that. So both the parties has to agree. Mr. So and so is present for the petitioner, however none appeared.
On behalf of G. Taluk.
However none appeared for the respondents. Let the matter be fixed in the next week.
Oblige.
Item number 19.
Yes, Your Worship, I'm appearing for 1 to 5, Your Worship. In this matter, Your Worship, the main party is the general manager. Sorry, the director of transport department, mini secretary, Nahalagan, Your Worship, which
Because
has
none is
not been.
appearing when the matter is,
Yes, Your Worship.
none appeared for the petitioner when the matter was called for.
Your Worship, may I pray that
None,
petitioner,
Huh.
petitioner may be directed to, petitioner counsel may be directed to implement the necessary party, Your Worship. Necessary party, Your Worship, so that we can issue the notice.
the petition is not there. If nobody is there, how can the order be? None appeared for the appellant when the matter was called for. However, MS so and so for
1 to 5.
for the respondents, our respondents is present. For the interest of justice, let the matter be fixed in the next week.
Okay.
Item number 20.
Office note dated 10/3/2026 reveals service on report of service or service on respondent numbers 1 and 2 is still awaited. Full stop. none appeared for the petitioner, when none appeared for the appellant when the matter was called for, let the matter be fixed after a week.
Matter number 21.
Anybody is appealing?
Lordship, I'm appearing for the petition.
So you want to go to the mediation?
Yes.
It is mediation or what?
But yes, mediation, but Lordship, service was not completed.
Service not completed?
Yes, Lordship.
Okay. Mr. So-and-so is present for the appellant, for the petitioner, as well as Mr. D. Loy for the learned APP for the state. Office note dated 10/3/2026 reveals that service report of service on respondent number 2 is still awaited. Let the matter be listed after a week.
Matter number 22.
My lordship. We are not ready for mediation, your lordship.
You are not ready for the mediation.
Yes, your lordship. We are not.
Okay, you have Miss MS,
Tirimi.
the learned counsel appearing for the petitioner, and also heard Miss MS
Tina Chuk.
for the respondent.
Yes, your lordship.
Respondent number 2,
No, sole respondent.
Only sole respondent. Your lordship.
sole respondent.
Yes, your lordship.
You weren't to go for mediation?
No, she is not ready, your lordship.
Your
Weren't
lord,
to try. You were the husband or what?
no, your lordship. I'm the wife.
You are the wife.
Yes, your lord.
No mediation.
No,
Why?
mediation.
Why?
Because
You don't want to settle it.
your lordship, I pray for dismiss of this matter, your lordship.
Okay, so and so for the respondent. Parties are not agreeable,
Your lordship,
not agreeable in sending the matter to for mediation.
Your lordship, a fixed date may be given, your lord.
reading is completed, so for admission, your lordship.
Let the matter be listed for admission on
24 of this month, your lordship.
24th March.
Obliged.
Obliged.
Matter number 3.
My lord, this is a my lord, application, my lord, seeking leave to file appeal, my lord.
The TCR is not received.
This is not received, my lord.
You heard Mr. R. Sonar, the learned counsel appearing for the petitioner. Also heard Mr. G. Tado, the learned
R4. Respondent 4.
R1 number 4. The office note,
Complaint letter. So there is a private respondent.
so notice has been issued or not?
And they have appeared in the court.
Wakalat file on behalf of 1, 2, and 3.
Yes.
Yeah, their name also appear in court.
Correct. So nobody appears.
We are actually proposing.
Correct. So I mean, otherwise also this matter is TCR is not received.
Yes.
So and none appeared for respondent number 1, 2, and 3. So Mr. Tado is appearing for respondent number 4. And office note dated 10/3/2024 reveals TCR is yet to be received from CJM Alo.
CJ, my lord.
3JM Alo. Registry to send a reminder for the TCR in connection with the case. So let the matter be listed after 2 weeks.
My lord.
Matter number 4.
May Lordship. Lordship, here, this civil revision petition, we have come before this honorable court.
Now none appears for the respondent.
Lordship.
Wakalat number not filed as yet.
Lordship, Lordship, here they had appeared before this honorable court saying they took time for 3 weeks to file the wakalan. And then after that, they have not filed the wakalan.
But we'll have to wait, I mean, without them, and how can we?
Lordship, the matter pending before the honorable court, Learned Civil Judge Senior Division, this is a money execution petition. Lordship. There also they have taken the same part, and here also, Lordship, they come and they are just seeking time, Lordship. So this is the reason, your Lord.
That this is, I mean, 10/3/2026 report says the no wakalatnama filed.
Yes, Lordship. Last order also, Lordship, the honorable court has given, if in the absence, the matter will be heard. Lordship, here in the Lok Adalat, I have settled a settlement between the petitioner, that is the degree holder.
Okay, I mean, we'll give them one more chance, and if it is not done, then we'll hear it. Because without, I mean, heard Mr. V. Jamo, the learned counsel for the petitioner, none appeared for the sole respondent.
Yes, Lordship.
None appeared for the sole respondent. Appeared for the sole respondent, full stop. Order dated 28/1/2026 indicates that on 17/11/2025, the sole respondent was represented and the learned counsel paid for time to file wakalatnama. However, till date, no wakalatnama has been filed. Wakalatnama has been filed as per the office report dated 10/3/2026. The learned counsel appearing for the petitioner has submitted that though sufficient time has been given to the sole respondent, the sole respondent has not appeared before this court by engaging a counsel. Full stop. In view of the aforesaid, he submits that the matter should be heard ex parte.
Yes.
Ex parte. Full stop. Taking into account the issue involved, this court is of the considered opinion that for the interest of justice, one opportunity should be given to the respondent to engage a counsel on behalf of him or her.
Him, Lordship, after publication of paper only, they had appeared before me.
On behalf of him. Let the matter be listed on when?
After, no, any date.
Let the matter be listed on,
Madam, maybe taken about 26.
let
Oh.
the matter be listed on 26th.
Hmm.
Let the matter be listed on 26th.
Development. On Lordship, on that, if they don't appear, that matter may be heard.
That, I mean, I have indicated that already that order was there. So if nobody appears, then
Lordship, here also, like after getting the execution,
they are not doing anything.
they have not appeared there also, and there also with after issuing of NBW civil warrant, they had appeared, and then they said they'll pay the amount, then they disappear again. And here also, Lordship, before the High Court also, we had filed paper publication for the appearance. Then they had appeared, and they took time. And
Who is the counsel?
counsel, Lordship? I don't know. It's written as some I Ramson.
You don't know him?
I don't know him, but I've spoken to the one who was appearing before them before the trial court. They are also saying he's not in touch with them.
Okay, let it be the next week. Next week court will decide, I mean, how to go with this.
That's developed.
Item number 5, it's a part matter.
I made a list of dates.
Hmm.
But before that, what I have done is, my lord, I have applied for the certified copy of that case. Of the case which your lordship has
Yes.
referred.
Ah.
And I applied for certified copy. I have gone through it because I have to go through that.
Ah.
I thought, let me go through it. What is the contention that they have made in their writ petition? Their prayer.
Could you go through that?
Yes, I have gone through it.
Ah.
I have gone through it. Certified copy, I can give it to the court and one.
No, I have the order. I have the order of.
Order is, my lord, your lordship is what is a writ petition? How they structured about the writ petition? Their prayer in the writ petition is denotify the preliminary, my lord, the notification that was issued in 1977.
That is one of the.
We did not made any prayer so far as striking of the preliminary notification.
You
of
want,
77.
you want the compensation, nothing else.
Now, my lord, preliminary notification, what I have read, I have some judgment of this court also, latest in 2025, that was passed by this court by Honorable Justice Fukan, which I have pointed out on the last occasion. Another judgment of this court in 2025 SCC, my lord, I'll place the facts. But if you, now I'll play the reverse. Let us
No,
play.
But Mr. Das, one thing is, I have noticed one thing,
Yes.
that you are already protected, interim order is there.
No, we are not.
Interim order is
No,
there.
no, not protected.
Why? This is, I mean.
There is
see,
no interim order.
Your main claim is only for compensation. But that
That
initial
interim
order,
order, that what I am on, my lord, no, what, this is, I was not the counsel at that time, my lord.
Hmm.
My lord,
But there was an interim order
there
passed.
was an interim order, there were two interim. Kindly see, what is the interim order that was passed by this court?
So interim order is to the effect that any construction in respect of package is concerned, if undertaken shall be without prejudice to the rights of the
No,
petitioners.
that's
came
one.
consideration.
That's one, there is absolutely no problem. If you see another prayer,
Hmm.
issue notice on interim prayer returnable by 4 weeks. Learned respondent to obtain update instruction by returnable date on which the interim prayer shall be considered. So that we said that there are two prayers. One is about the compensation you will get. Suppose tomorrow, now court find that this preliminary notification has no applicability at all. It doesn't amount to is not as good as reserve forest. And that thing goes. Then, my lord, this is a very important project. Then, my lord, we are entitled to get compensation.
But your
They
prayer-
cannot
but-
deny
but-
compensation.
But your prayer is not that.
Yes, kindly see.
Let us see the prayers.
Yes. My prayer is this, man.
Your prayer is quashing of the, first prayer is
Yes.
quashing of the notification,
Yes.
right? 5th September. Now, what is happening to, this chief secretary? Who is appearing for chief secretary?
I am your worship.
Then why affidavit is not filed?
Yes, on behalf of the Deputy Commissioner, your worship, we
Hmm?
file your worship.
Then the chief secretary is the one who has issued the notification, right?
Yes, your worship.
Hmm?
No, we
No,
have
your
been-
worship.
we have given, my lord.
Hmm?
Claim for compensation, Roman 5, page 68.
Roman 5.
Yes. Maybe issue direction, response authority considered.
Compensation
Claim.
you have, compensation you have.
Yes.
But you have not challenged that, preliminary notification.
No, I don't have. I don't
You
have
don't
to
have.
challenge. I don't have to challenge.
Hmm.
I'll show
Hmm.
why I don't have to. By by virtue of it,
Hmm.
if a preliminary notification, my lord, it is not as good as reserve forest, not as good as reserve forest, then it cannot be counted. Then I am entitled to get compensation.
So preliminary notification will not have any effect.
No effect.
Hmm.
Then there has to be an acquisition. And that's what our High Court in 2025 said clearly.
So your case is that till date, there is no final notification.
No final notification.
So if there is no final notification, there is no value carries by the notification which has been issued preliminary.
My lord,
phase.
let's say it is very important project,
Hmm.
but they have not followed any procedure.
Hmm.
What is the effect, my lord? It may be an important project, but as per the law, you have not followed the project, then it will fall down, my lord.
Hmm.
Nothing will remain.
Correct. But now at this stage, what interim relief you are?
I want that interim relief to the extent that so far as the part which they are carrying construction, they should first stop one. Secondly, with their person, my person should go to that place, look into it. What are the giraffes, like value of that compensation? I should get it. They should assess. These are the but otherwise.
Girard, have you claimed Girard?
No, the compensation is all amounting to under.
You have only asked
right
for
to
the,
fair.
you have only asked for the land compensation.
No, my lord, right to fair. Section, everything will include. If it is right to fair compensation, if I have claim right
Something
to
is there
fair,
also, they'll-
automatically it will. Then I am entitled to get section 29 also. I am entitled to get Solicium also. Everything I am entitled under the Lara Act, 2013. That's what basically my claim was. But only apprehensive is that what will happen to my Jirat, whether I will get compensation or not. That they have not assessed. the NSSGCL has gone themselves. But my lord, all the representation, every notice which they have sent, I can show it. My list of dates, everything was written in my representation. That how can you do it? You have not followed the procedure under 5 to 17. That also has been mentioned. All the representation. Now, while deciding an issue, saying the greenfield alignment, settlement without habitation, how can you take a decision ex parte without calling us? You should have called us. Against that objection has been filed. Against 4/7/2025, also I have seen, my lord, an objection has been filed. Each and every letter they have received and it has been filed before them, but no action has been taken by them. Green alignment
So
today
you have submitted so many representations, none of the representation was
not has
answered to.
not has been addressed to it. Why they have not? They should have said address to me. They said no, you can't do it for these various reasons. They have not addressed. Now, secondly, one letter is very important, where the DFO has stated also.
And that is excluded.
Your lordship has seen. No. What the DFO has said that I cannot issue a notification.
Now, he said that NOC cannot be given on the whole land because 58 hectares or something is excluded.
Yes. Now what they are saying.
If they exclude it, then he can give a notification.
Now there is no question of any exclusion of 50.
Now, is there in the preliminary notification, is there any, clause or something like that stating that certain portion will be excluded?
What they said, if you see in the preliminary notification, in last note they have said 50 square meter will be excluded, has been excluded. They have stated in the preliminary notification. 50 square kilometers has been excluded in the notification of 1977. But which is, they could not identify. Just they said 50 square kilometer will be excluded. Because what the procedure, there has a process, how to follow. They did not follow that process.
No,
They
that
themselves
admittedly
admitted.
they have not
So
followed that.
when they have not followed the process, what is the ultimate, my lord? Now today, it is a stand taken by them. Also, our case is that you have not followed the procedure. Now, if you don't follow the procedure, then everything will fall down. So you said we are not entitled to get a compensation because it is a reserve forest. It is as good. They said it is a reserve forest. So you are not entitled to get compensation. Very well. If it is a reserve forest, you have followed all the procedure, we have no claim. Then I cannot claim compensation if it is a reserve forest. If it is not a reserve forest, you have not followed the procedure from section 6 to 17. So automatically it will go, nothing will remain. So right title and ownership will remain, will vest to us. That is why, my lord, we will kindly see.
The act,
My lord will kindly bear it for a moment of the judgment of this court in 2025. 2025, I have one copy with me. Please see the judgment, my lord, in latest 2025 on this subject. Subject is same.
This is by the coordinate bench of this court, right?
No, that is one. Another judgment of coordinate bench.
One is the Masang Pada.
Yes, this judgment.
This one is?
No, another judgment.
Okay.
This judgment I have not. I got that there is another judgment.
Okay.
This is another judgment. See para 14. What I find that if law we know, because there are certain facts we should know it. But here is absolutely on law. See para 14.
Yes.
It is an admitted position that the petitioner are the permanent resident of the aforesaid villages and construction of 132 kV transmission line under comprehensive scheme shall be over the land in question. It is also an admitted position that the preliminary notification was issued on 1/12/1975 for constitution of Deka Reserve Forest consists of land in question claimed by petitioner. It is noticed that the preliminary notification could not be brought to its logical conclusion by finalizing the notification constituting the proposed Deka Reserve Forest. Records also reveals that there is no final notification notifying the Deka Reserve Forest except the aforementioned preliminary notification issued back in the year 1975, which was put to hold on the opposition of people of the area, including the petitioner. Paragraph 15. As the order passed by the Honorable Supreme Court, from time to time, the land consists of the area remains the forest land. However, the state like Arunachal Pradesh has a peculiar system of ownership over the land customarily either by individually or community. On perusal of the records, although various approvals have been granted by different appropriate authorities for diversion of the said land for construction of 132 kV transmission line under comprehensive scheme, unless the land being owned by the people, including the petitioner, notified as reserve forest, the right and title over the land by the people, including the petitioner, cannot be brushed aside. Thus, in my considered opinion, the petitioner having the title and ownership over the land, although the land remains as a forest land. Having viewed the petitioner, the owners of the land in question in terms of categorical statement of the additional deputy commissioner of the concerned area that there is no reserve forest in the area and proper verification assessment has been made with regard to constitution of reserve forest as well as assessment, I am of the view the petitioner would be entitled for compensation and damage. Now, this is, they have mentioned 10, 16, but the fact remains that this being not a reserve forest and they have not followed the procedure, whatever the steps you have been taken by the authority, but that will not stand. Now, my lord will kindly see in our writ petition.
So ultimately, what was the conclusion of
Yes.
in the case?
My lord will kindly see last para 24. And para 23 also, para 24. In view of the above, it is directed to respond authority to verify and assess the damage for compensation in terms of Indian Telegraph Act, Electricity Act, and a notification of the state of Arunachal Pradesh dated 29/8/2019 within a period of 2 months from the date of receipt of certified copy. Thereafter, assessment be submitted before the appropriate authority, and the responding authority on receipt of the assessment submitted by the authority shall pay the compensation damages to the petitioner in a period not later than 3 months from the date of receipt of such assessment. Now, please see, my lord, at page 500, kindly see.
So what is their stand?
Their stand is it is not.
Who has filed the affidavit? Only the director of land.
No, Your Lordship, the
land
deputy
settlement,
commissioner, Your
huh?
Lordship. The deputy commissioner.
Deputy commissioner.
Yes, Your Lordship.
Anybody else?
No, Your Lordship.
And you have filed an affidavit, right?
NSADCL has filed.
NSADCL has filed, okay. So 2 affidavits have been filed.
But
Yes.
Only deputy commissioner.
Yes, Your Lordship.
But your high officials are not
The
filed any
land
affidavit.
management department has said that they don't have any say in this matter, Your Lordship.
They don't have any say.
Yes, Your Lordship.
You are appealing for them also?
Yes, Your Lordship. I have taken the instructions.
Respondent number?
Um,
Respondent number?
2, Your Lordship, 2 and 3.
2 and 3 said that they don't have any, anything to do with this matter.
Yes,
They don't have any say.
Because Your Lordship, the forest department is claiming that this is a proposed reserve forest area also.
So they are claiming that this is since it is under proposed, proposed reserve forest or reserve forest. I mean, they are claiming it as good as reserve forest, right? So they are saying that this is not, this is not, this is nothing to do with them,
Yes, sir.
correct?
Yes, sir.
So this is on instruction you are submitting, right?
On oral instruction, yes, sir.
There is nothing called oral instructions. Oral instructions.
Yes, but I haven't received in written, Your Lordship.
Huh?
I have only telephonically I have been instructed, Your Lordship.
No, whatever. This will go on record that
Yes.
on instruction they don't have anything to say. And what about? Let me see the other. Mr. Das for a second.
Yes, yes.
Then.
And as far as the
So, Chief Secretary, you are appearing.
yes, Your Lordship.
So he hasn't filed any affidavit.
Your Lordship, usually the chief secretary, when we send
So Chief Secretary has authorized the
secretary land management and
So-
director. Your Lordship.
Secretary.
land.
land management,
Yes.
secondary land management.
So
has filed
he is
an-
answerable to all the queries. of the
Whether
court.
he has filed an FIR. Oh, sorry.
Sorry. Your Lordship.
Whether he has filed any affidavit.
No, Your Lordship, till
I
that.
keep on taking criminal matters, so it comes FIR only.
Yes, Your Lordship.
This, he hasn't filed an affidavit.
No, Your
Why?
Lordship, till,
You are appealing for him.
yes, Your Lordship.
Why you haven't filed?
As I was earlier saying, Your Lordship, they don't have any
Hmm?
say in this regard.
Anyway, I mean, since you have not filed, then
Yes, Your
I
Lordship.
can't say anything, but no affidavit filed.
Since Your Lordship, today is for the interim, Your Lordship.
No, today we'll dispose it of. We said last time that if required, we'll dispose it of. We'll see how it progresses.
Yes, Your Lordship.
Last time I intimated. that
Yes, sure,
It will be either for interim or if time permits and everything, I mean, we can dispose it of. I'll see how it progresses. Then 3, Director of Land Management,
Yes.
3 has filed,
No,
No.
Your Lordship.
no affidavit.
Only 5 has filed, Your Lordship.
And what is your instruction on this for respondent number 3?
It's same, Your Lordship.
Same.
Yes.
4, no, 4 hasn't filed,
No, Your Lordship, for
no affidavit. 5
5 has filed, Your Lordship.
filed affidavit. 5 is filed only on his behalf, right? On his own behalf.
Yes, Your Lordship.
Then 5, then 7 has filed, right? 7 and 8 filed. 7 and 8 filed. See, there is no point, I mean, lingering with this matter. If the issue can be settled at this stage, why not? Rather than, yes.
Without any everyone. So why not 40 being doesn't into 41? 41 for obviously culture getting into. And 41 only Lara.
Hmm.
We can pay everything completely 80% payment continue. We pay off. Article is end of the day, your lordship has seen that this proposed result for it, there is no procedure that will follow. All the judgment of this bank could be made that also has started, but unless poultry is observed by this state, that's a different.
Correct, I mean, then,
Your optical hold on, I don't know, but I get all the cognitive judgment in respect of section 5. And all the judgments say that you have to follow this. One of the judgments which I have shown now, that by the bail, is 500, that is 500 of my
yes, that.
500 for a money. What it says, 500.
Yes.
See, page 523, what's it got to? See, 36. From the tax and survey degrees that the forest villagers of forensics who are living in these forests for centuries together were oblivious of any declaration of reserve forest, were happily living in their ancestral dwellings without any disturbance whatsoever. Apparently, the state government also did not take the details of forest villagers of so and so, while taking necessary steps for construction of Delhi Reserve Forest. In the last area of Delhi Reserve Forest, around 6.41 hectares of land declared and notified by the state government, apparently village so and so, got included in the notified area by default. On perusal of the above document is clearly revealed. The state government admits the existence of forest village in so and so, but very surprisingly, the state government could not rise to the occasion either to address the issue of rehabilitating the forest villager by duly compensating them or by awarding due compensation in terms of the Land Acquisition Act. Now, my lord, please kindly see that pertains to some army taking over the land by army. If your lordship kindly see para 52, see para 52 at page 531, conclusion.
Yes.
Consequently, without regarding the discussion made further, in view of the above, I find that Gazette notification dated 16 to 1973
issued under section 5 of the Assam Forest Regulation 1891 and Gazette Notification 11868 dated 29/1977 issued under, now here one step more, issued under section 70 of the Assam Forest Regulation Act proposing and constituting of the gaming reserve forest covering the area of so and so is in violation of the, or is it violation of the provision of the Assam Forest Regulation 1891 and Bandipara so and so, and other related notification are now be declared null and void. However, learned counsel for the petition on instructor submitted petition of the landowners who are patriotic Indians living in the region bordering China are aware of the duties and responsibility to a nation building and are able to give away the right to over the existing land for being utilized for key location point by the Indian Army for the services of the nation. Learned counsel submitted. Nonetheless, the villagers are entitled to land compensation as envisaged on the different acts, rules and policies governing the field to enable them to decently behave with animals. So there are two things. Either you have to pay compensation, and for resettlement, you have to pay to another. For that purpose, suppose I don't want to go for resettlement, I get the benefit of monetary wages. But I choose, number one, land compensation to be paid. Number two, rehabilitate your place, but I don't choose monetary benefit. I will not get it. But I doesn't choose the rehabilitation resettlement policy in persons that what I can do, I can claim my monetary benefit.
In addition to your,
Addition.
in addition to the compensation for the land, compensation to the land, you are saying that like, if you do not go for their scheme of rehabilitation, then you will be getting some, then we should be eligible for additional monetary compensation.
They are also aware of it. There is a need of patriotic people. They also be surrendering. But by surrendering doesn't mean that it is I not get the benefit. You keep the benefit you want for a purpose which is very important purpose for you. You pay us compensation for what you are saying. And I have seen a letter addressed by Chief Minister. I will show that letter addressed by Chief Minister saying that is a greenfield alignment. So it is a greenfield alignment for this area package number 3. So there is no question of acquisition of this land. There is no question of compensation, no question of giving a notification. We have the right. Greenfield alignment, no application was attended. They review.
The greenfield alignment, I mean, wait, is it defined somewhere? What is greenfield alignment? They say that it only because it's a reserve forest. That is the concept of it. But there is no, I mean, greenfield alignment, something like that. See, I mean, Mr. Counsel, your case is already, there are so many cases decided by the coordinate bench as far as notification is concerned.
Yes, Your Lord.
So this is binding on us.
Yes, Your
So
Lord.
if your notification goes,
Yes.
your preliminary notification is, preliminary notification goes. Yeah, I mean, we did not set aside the preliminary notification, but on the face of preliminary notification also,
Yes.
because final notification hasn't been issued as
Yes.
per section 17 of the act,
Yes, Your Lord.
then this is not a reserve forest. You can't say it's a reserve forest.
Yes.
Only is a proposed reserve forest.
I agree.
So if it is, I mean, till that time it is not declared a reserve forest, then these people have the right.
Yes,
of
Your Lord. They
compensation.
have the
So,
right.
so that has been decided in many cases.
Yes, Your Lord.
Now on the face of that,
Yes, Your Lord.
what is your submission?
I have nothing more to submit apart from this judgment of this subordinate court of this honorable court.
Then we'll have to stay the whole work. Then we'll have to stay the whole work and ask you to compensate them. Are you agreeable to that?
Otherwise, Your Lordship, my
No.
colleagues-
Otherwise, question doesn't come. See, thing is that legally, what I mean, this court can find till now is that one preliminary notification was issued way back in 1977.
Yes, Your Lordship.
Correct.
Yes, Your Lord.
That notification is there.
Yes.
It was there in the official gazette. Now, as per the law, there are some certain processes you need to follow till the time you issue a final notification. Correct.
Yes, Your Lordship.
Now, there is no material before this court that you have followed those processes.
Yeah.
Nothing is there.
Yes, Your Lordship.
Now you are saying that you admittedly you are saying that no final notification has been issued.
Yes, Your Lordship.
Now, on what basis you are saying that land is a reserve forest? You answer me that.
In that, Your Lordship, I don't have any speakers.
Hmm?
Because
See, I will record this. I'm specifically asking you, on what basis you are saying that is a reserve forest and thereby denying the compensation to the inhabitants of that place. And they have brought in record that they have been staying in the same place since before 1951. Their names were there in the census.
yes, Your Lordship.
Their names, they have been issued gun licenses. They have been issued so many things.
Yes, Your Lordship.
Government authorities in the same address,
Yes, Your Lordship.
in the same villages.
Yes.
So you can't deny that they have not been staying there.
As per the affidavit of Deputy Commissioner, he is not denying that they are not the resident.
Correct. So they have been staying there.
Yes, Your Lordship.
Now, admittedly, when I asked you that whether any whether the process has been followed, there is no material before this court showing that after issuance of the notification of 1977, certain processes have been followed, and this notification is about to be published.
Yes, Your Lordship. It has
Final notification.
confirmed by the RTI reply.
So there's nothing, and
Yes.
there is no material to show that, one notification was issued in 1977.
Yes, Your
Generations have died. They
Yes.
don't remember that notification. And suddenly you come up and say that no, that notification was there. So we are now issuing the final notification. Can you take away their rights? They have been staying there for so many, from generations to generations. Indigenous people.
Even Your Lordship, I am also engineers of Arunachal Pradesh, Your Lordship.
Mm. So you also from the place?
Yes, Your Lordship. I am also from Arunachal Pradesh itself.
No, Arunachal Pradesh, I know, but it's that same place over.
No, Your Lordship. Why I am only to the extent of interim is, Your Lordship, that project, it's connecting two district, Your Lordship.
See, you are not responsible. Your government is not responsible. If your government would have been responsible, they would have come to this court and say something. Their government is not responsible. We are not taking any steps. Now you are saying that temporary measures, some interim orders to be passed, this and that. But ultimately what happens that if the whole project, this notification is cancelled and you have to pay all the compensation to them, you'll have to divert the road or something like that. That kind of thing comes up, then what will you do? Who will take the risk? You tell me. If some dispute comes about the compensation, NHIDCL has to ultimately pay. NHIDCL says that I don't want to pay. You told me that this is your forest land.
Can we see a
Face?
630 of their applicants. NSA is 633.
633.
NSA is
Oh, it is separate. Yes, affidavit is separate.
that is
Yes. Yeah.
address to receipt.
Hmm.
I just receipt package fee. It is required to acquire 384.90 hectares of land of construction medium rainbow from so and so. Details were finally pick up. It is requested. Land acquisition for the subject project may be done under Lara Act and Urgency Clause 41 of Lara Act 2013 with the exemption of any additional public law for acquisition of land concern, defense services and national security property. Now they can't say that exemption from any additional, that is up to the authority to decide whether I am entitled, what I am entitled in the court. But there let us specifically say that you please invoke access to DC. Kindly see my. It is not that they are not saying that no. We are ready, we are requiring authority. We are ready to do it. We are ready to give compensation, but urgency clause can be
40.
40 can be. 40 can be invoked and accordingly our compensation can be paid. The problem here is that, my lord, we will get it even. Now the problem will be Jira. This is a big difficulty for us. That's how we are covering the court. We once, twice, we cover the court. I can also bear to cover the court. But ultimately, Jira, how they can be calculated under section 20. Once it is over, then there is no question. I will not get it. And this is my forefather's generation. They have oranges are there, cardamons are there, big trees are there. Some portion they have done it. What remaining portion, at least we should get it. It is my generation, forefathers, they have built up. So today, what I will get it, man? I don't think anything. Apparently, on the face of it, they can't do it, if you see it. NSC DCL wants that no, 40 can be. Go and pay to the claim that have been claimed by the landowners, pay to them 40. And 40 or 40, no, there is no question of a notification. There is no question of a preliminary notice kind of issue for acquisition or for defense purpose. Even then, there are cases which are 41 can be invoked for issuing a notification. But there is no question of possession. There is no question of objection. It is this land under 41 for defense purpose. We want to acquire it. Now, what will we do with my law? Immediately, they will give a notice to the parties. They are within certain 45 days under section 21 of the Law Act. They are willing to take this possession of the land. 21. Section 21, then the provision for giving notice to all the land. And notice will be given, and after the period, after the notification, 45 days they will give. And after, then they will take possession of the land. This is under 41, there is the urgency clause. I remember. 41 and 21 is the notice. See 40 minus section 40.
How do you become consumer?
How do
Some 40 years.
40. Now, my law will privacy for. Now, C40.
Yes.
Special powers in case of urgency to acquire land in certain cases. My law, your object please note down. Earlier, 1894, parameter is 1670. Section 70,
Now it's 40.
In case of urgency, whenever the appropriate comments are there, the collector knows such award has been made, they on the expiration of 30 days from the publication of notice mentioned in section 21. They take possession of any land needed for public purpose and such land shall thereupon where absolutely government free from all encumbrance. Now, if you see appropriate government, kindly see what is definition of appropriate government means. Section 3P.
Yes.
Now, appropriate government means in relation to acquisition of land situated in the territory or take of government by kindly see. In relation to acquisition of land for the purpose of union as may be specified by notification of the central government. Provided that in respect of public purpose in the district or area not exceeding such a thing notified by the appropriate government, collector of such disease and the became appropriate ground. Now, the requiring authority now they are saying we don't have any problem. If it is under 40 also. Now see 42 minus see 40. Now 21 times see 21. See 21. See 21. Section 21. Notice the person interested. Collectors and public notice on the website and for public notice they are given at convenient place or on the other land indicated, stating the government intends to take possession of the land and that aims to complement the education and settlement for all interim settlement may be made to him. So this is the notice which can be given under section 21 as per 40. Now if you see 40, now if you go back again to 40, 40 mile of kindly see 3, 40 subsection 3. Before taking possession of any land under subsection 1 or subsection 2, collector shall tender payment of 80% of the comprehensive process land as estimated by him to the person interested. So now there is a case, they did not invoke. They requested to invoke 41 and Lara under Lara. Now Lara Act says 141. For immediate, for urgency clause, we can either without issuing any invitation or award will pass, but no, they can.
Yeah, but thing is that now whether this court can direct that.
No, we can, your office
I cannot direct
it. Because their intention of NCDCL was that no, we are agreeing. Under for that what I am sure. Your lordship is not.
Yeah, correct, correct.
Your lordship cannot be what saying their intent. NCDCL was ready. The 41, if you invoke, 41 said that whoever decided, landowner has to get a legal compensation. And that to 80% before that. Before taking out 80% before taking police. Your lordship will not found that out.
No, that cannot be. That's why I'm asking because.
That whether you can enter the without following the due process. Because section 5, here it's a law. Section 5 is the procedure. What is the criminal notification? Thereafter, there are a procedure which will be later. 6 to 7. You have not for any. Now the codicils of this code in various of the judgments say that if the procedure is not followed, automatically it will follow. So what culminates? If it falls down, today the logic holds that this is with an absolutely cannot acquire without following the procedure. Automatically it falls down. So there is no question of going ahead with the construction. You cannot go ahead with the construction.
No, that is the. I mean, that is the problem because it's a. This is supposedly it's a very important project.
Go back. It's a very important project. It is a very important project. But important project, you don't follow the procedure, then automatically.
Yeah, correct. So that they will suffer. That's what I'm worried about. I'm worried about that only. It's an important public project, and you are not following it, and you are not invoking section 40 also. Now, I mean, your stand is only thing is there's a proposed that if the whole thing goes, then it will be bigger risk to you. That will be bigger risk.
Now,
Your whole thing goes, then I mean, you'll have to stop the work.
Yes,
At least for certain time, maybe. At least till the land is acquired, paid them, all those things.
when you enter the as far as we can do this best.
Section 40 is there. 40 is there. 40 immediately they can do it.
Immediately, 1 month they can do.
But if they wait for court to say,
Really, I am saying in this case, that what is the article? The working today, your logic holds that this process which they have done is not taken with the IRP, right? Then the process which they have carried out that becomes illegal, that become nullity, that become illegal. Then number 3, then you cannot proceed. Now number 4, if you really want to proceed, then what you have to do, you have to order what is the provision that under Lara Act is applicable. Or under the various provisions of law which are entitled to get
the land.
Yeah.
So that will take process the whole hell of a time then again.
No. They have gotten any manual paper. That also is difficult for them.
Okay, so they have the calculations.
Can be done under land this manual 2020. That is not a problem for
So they have a calculation.
Solicium and 29 has to be invoked the law. But so far as value of the land is concerned, that is guided under the manual of 2022. Manual of 2022. And the CPC.
Land manual of Arunachal Pradesh.
Land.
Manual for land acquisition. Manual for land acquisition. 2022. Yes. Now, Mr. Das, what do you suggest? What do you say?
Their position is by them itself that they have not completed. That's it. But it is an important question. So what is the effect of it? Now important project. If you have not followed the procedure, the important project has to be stayed. Now we the sufferer will be the complicated law at this stage. Everyone will suffer for it. But they have admitted themselves that we have not followed the procedure at all. If they have not followed procedure, by only saying that it becomes a lesson important for them, they may continue to do wrong. That your lordship will not allow. Why? That is the judgment of the Supreme Court in 2008, 8 SSC case 648, which I have shown. Continuance wrong cannot be committed by them.
They are Tufan Singh wala this.
Yes, that is Tarsen Singh,
Sorry, Tarsen Singh.
paragraph 7. I think a lot is holding that.
Yes, it is there. Yes.
That will not be allowed to continue. How can you be allowed to continue? Some wrong has been committed.
Admitted wrong, which admitted wrong cannot be allowed to continue.
Continue. You cannot perpetrate to continue. How can you go ahead with the work? The sufferer is the community or the person concerned.
So, Mr. Counsel, what is your this thing?
Can I suggest one thing? Submit to your evaluation. Because this is a huge task. This will never end 1 or 2 days. I know you're working well because of an important project. But on the present biography also they have not adhered to the condition. So what your lordship can direct that these are the factual part. These are they have not followed because their own admission like that. So what I am saying that so particular period, so within this period, my statement here is that they will not continue. Yes, whoever has not come, that will continue. That also is it bigger. That your lordship, I am not saying to exercise more on it because whatever the land which they want, they are constructing, then they need to stop for a period of 15 days, 20 days. Let them come to the court. How 15, 20 days will make a difference if they are, well, by that time, what they can do is they can calculate the data along with us. Committee can be formed. This which in the letter, by of which the Deputy Commissioner requested, a committee will be constituted. Your claim, DC, NSADC will be there, but they have cancelled. This is my case on record. Kindly see, I have given the list of dates now. I have given the Hello, 4/7/2000.
I think this is 314 page. 24/7.
211, kindly see page 211. 211, they say, dated is 23/6/2025. 23/6/2020.
Yes.
23/6/1.
In suppression of the earlier circular so and so, the coordination meeting of the committee members is fixed on his and cancels.
Now, if you see the circular, I was it was office on the circular. If there is a take 209. 209 C 209 circular. See the circular.
Yes.
In furtherance of the order of Deputy Commissioner Procedural is never fixed on 24th of June 2025 at 11 hours in the office chamber of the undersigned regarding the verification, inspection of land measuring thickness for excluded from total area to be effort for construction of prevention. Committee may have requested the attend the meeting on the above date and time of the day. Now type copy is 210. Now 23rd of June.
So they have cancelled it.
Now, before that time, we see, my lord 4/7/2025, which I have impugned. 259. See 259.
Can we resume after 2? Mr. Das,
Yeah.
if there is something.
So 5 minutes, my lord, I don't know. Yeah.
Okay.
Please, but after 5 minutes.
Yes, because I also, oh, yes, fine. 5 minutes we can.
Only 5 minutes.
No, yes, please.
My lord, kindly, yes. People, take it 4/7/2025. That one is going-
Because it cannot be concluded, I mean, difficult. So what is to be done?
So, I will continue now. Sorry.
Because we'll see it at 2:10 because I have something, at now, at the attorney.
Whichever is coming here, 2:30, what is coming, I am there. No problem.
Yeah, after this thing, or when you finish there, when you finish, then you can intimate the court officer.
I'm with you.
Yes.
Our patent represent is 74 to 85.
Mhm. Yes.
For the power of the movement,
Mhm.
now 74 to 85. So few of the person have given this power of the who are Mr. Pura. You see that page 74,
Mhm.
74. Then one power of equity. We have page 77. It is up to 85. Right?
Yes.
Yes. Are represented by the community. Yes.
So you don't have any issue in this, no?
Pardon, Your Worship.
You don't have any issue in this?
No, Your Worship.
I thought I.
No, that's fine. I'm just clarifying to you. Because, yes, well, then that's why I'm asking, immediately I'm asking him so that, let his, let him, as his, they don't have this.
I got also, I prepared on the climates. If I objection then. Now, my lord, thereafter, your lordship is turned to 286.
86 years.
86. Type copy is at 87.
Yes.
87 is and read this. On 81, type copy will remain notification and we can move it to 86.
That's fine, and I have that.
This is section 5. Right? If you also wanted to know, please see bottom, note where,
Hmm.
an area of 50 square kilometers is included from the above area for the legislative units. Total is 91967 square kilometers. The right proposed is of
So 50 square meters have been excluded, but which 50 kilometer that has not been identified?
Now, this is the how in the issue. We want to show ourselves that we were part of that land from page 19. That is the government set the issue. Page 19 the type copy. Then followed by from page 90 to 105. Please note that 92, page 92 to 105. In the census 1961, 1971, 1981, and 2000. People watching kindly turn to page 94. Please mark serial number 70. Here remove the digit.
18, 19, 18, 20,
19, 20, 21, and 32.
25?
25. 25. Now, the 1971 census.
So these are the, villages with the household,
Yeah.
number of households.
Then also at page 92, this is census of 1971.
92?
90,
No, not 97.
96. Sorry, 96. At page 97. Got it?
Yes.
So long as going down to 20. That's the name and village. 4858. Got it? Bamnan. Then.
Chiblam Bliang or something like that.
Now. 90, it is a type copy.
Then this is
98 is the type copy.
Then 81.
Census also, let's say 100, 4, 18, 21. Okay.
Yes. So this,
So I want to show you.
from where?
So the types of people. Now thereafter,
So you have been continuously staying there. I mean, your forefathers have been continuing.
some people have gone from there of that age. They went to a different place, but main cultivation is only. Because source of livelihood is from their cultivation, from the source of their area. And origin is entrepreneurs, all things are there. Now, if 106 is the representation to the DC.
Yes.
Community. Now, it starts from representation starts from 106 to 206. Now, if you see at page 106, it is a Bo community clan. Now, this is page 106 to 149. 114. From 106 to 149 is Bo community clan representation.
So different communities have given different representation, and some representations were jointly given
Yes,
also.
right. Now, if you see a page 150, 150, please see the representation of 150. The representation by India clan.
Yes. Yes.
At page 150, if you see a paragraph 2, there's certainly understand is likely applied that the first our forefather namely so and so, while residing at so and so during the year of 1910, along with others forefather namely so and so, India and late so and so for cultivation part. And from those days, next generation is coming up to now. Now, sir, during the year 1945, before independence of India, our forefather was shifted from our indigenous ancestors and so to various villages by the British government subject to cultivation work for potential land and various villages. Further, we would like to apprise our forefathers also born at rights that, sir, the undersigned would like to apprise that the descendants of aforesaid forefathers still valid to cultivation by cardamom, orange, etc. of the same area. Hence, being the absolute owner of the aforesaid area is liable to get the title of the land ownership of the aforesaid area. 151. The national highways so and so shall request and those and stretch into our ancestral area to construction of highway road connecting from so and so road, then the concerned authority must have to take compensation against our aforesaid area to us, actual landowner, and further would like to submit that in the outside and will make anything regarding the land ownership against our aforesaid area and settlement, still will not impact to us and you are registering it. I will take that in as basis. This is my own interpretation because submitted on 28/8/2024. Now, please hold on my with. Now, if you see a 154 is the representation by India plan. Plan. Now see paragraph 155. This is our genealogy has been shown at page 155.
That is the, I mean, see, now they are not disputing all this. They are not.
This whole, I was just want to show that it's not that we have not reached by representation today. But they were sitting that they were not.
No, that I have seen because, I mean, in spite of various representations, no reply has been given till now.
Now, please be 207. 3,207.
This is for the issuance of the
11th of February.
NOC.
Stop this.
Yes.
11th of February, column number 5. This is important, where it starts. Those are repeated. Please mark 11th of February, 2025.
So deputy, DC writes for an NOC from the DFO. Hmm.
You got it?
Then he replies.
Start page 208.
Hmm.
Please, now next date.
Hmm.
This why they have written. Just your logic can mark it. 11th to 2025. There is another letter of 10th of February 2025,
Mhm.
which is page 644 of the LHCC affidavit. Their affidavit, we could not annex it.
Hmm.
Now, prior to 11th of February 2025, at page 644, the logic can be seen. 644, which is the list of dates.
Mhm.
I have the list of dates.
Yes, this is the 644. What is that?
6. Letter of February. Yes.
Yes. Deputy Commissioner to Executive Director Projects.
Yeah.
Hmm.
This is last paragraph. Further as the notification whereby related to district from the local limited, it has come to notice that area of 50 square kilometer has been excluded for the use of villagers in the nearer Dala area. The issue of excluded area can be addressed only after obtaining NOC from the forwarded party.
Hmm.
Okay. That is now see 11th of February 2025. That is at page 207 of our report. This is because of that letter of the. Now this will connect. That's why this for this I put that it can be easily connected.
It can be connected.
Yes.
Lordship got it? Now, please turn to next page 208.
Yes, his reply.
This is his reply 21 to very interesting reply. With reference to above quoted, it is to inform you from the content of letter, it is not clear that whether an area measuring 384.9 hectares is to be acquired for the construction of so and so package tree is a part of area 50 square meter excluded from so and so, because your lordship has looked into it, the RTI, they couldn't identify. And this exercise has not been by them. Admitted position. In this regard, it is to inform if the said area of 384.90 is a part of 50 square kilometer excluded from Dalai Reserve Forest for the use of villagers, then this department has no objection for acquisition of said land, subject to consent of the affected villagers. In this regard, Section 5, 6, 7 of Assam Forest Regulation may kindly be referred to it. While the DFO is also new, it cannot be done without following all these procedure. Now say, however, to know
38490 area is your area.
3849, we said it is a part of 50 square kilometer, it falls under 384.
No, this 38490.
Yes.
That is a part of your area.
My area. We said that 50 square kilometer falls under that. They could not. They by notification 77, they said we'll exclude. But they could not exclude. Where is the question of excluding it when you don't follow the procedure of excluding? First, you have to exclude, follow the procedure. My lord, they have to follow the procedure, then they can exclude. They have not followed the procedure, there is no question of excluding it. And what we are saying, 384.90 is a part of 50. Now, what he says, my lord, last paragraph. However, to know the exact status of land in question, example 384.90 hectares, I request you to form a committee comprising representative of district administration, NSIDCL, and the landowners to physically verify the land and submit the ground truthing reports to avoid future complicacy as the excluded area of 50 square kilometer from Dalai proposed reserve forest has not been delineated in detail so far from your good office. Now, at 209, That is next date is.
So they have issued this certificate circular.
Yes, they have issued this circular. What I made, my lord, that list of dates is in serial. I have made the list of
Yes,
dates. So your lordship, we have mentioned, which is not with us. We mentioned the page of the affidavit that has been filed by
File there.
Deputy Commissioner. NSGCI. No?
NSDCL.
Yes. Now page circular regarding about the meeting of 18th of June, and on 23rd of June 2025, my lord.
The circular was issued.
This circular was issued where they decided, which was fixed,
That was cancelled.
cancel. It was cancelled, and once it was cancelled at page 212, kindly see, my lord, at 212. Lordship got it?
Yes.
212 is a representation to PMO. And if your lordship looks into it, at page 217, see page 217, paragraph 14.
Yes.
That, sir, it is apprise you that C so and so has not issued a certificate of jungle trees clear in respect to aforesaid proposed project, that is construction of so and so package tree. Furthermore, we have noticed all the forest clearance work have been kept in abeyance so and made irrelevant objection without any reason in respect to aforesaid proposed project. Due to such official or state development is being struck in track, therefore you kindly authority highly requested transferred, because he was making the main problem. Now my lord will see at page 21, same paragraph 15. That, sir, it is to apprise you that the company has already escrowed the land reserved for have been acquired by excluded from the for the construction of National Highway 15 so and so for construction of National Highway, despite having falls on the reserve forest, aforesaid land have been excluded by competent authority for construction National Highway. But very unfortunately, competent authority and so are being raised unnecessary objection inspection in respect our community land will falls under package 3, and till date our community land are not excluded from which is not count under notified reserve forest. Now if you see paragraph 16, my lord. We have mentioned about the paragraph. Now paragraph 18 also, 219. That's the law Deputy Commissioner is the Forest Settlement Officer empowered to exclude the proposed reserve for a user village. Therefore, we the landowner request with folded hands before District Administrator Deputy Commissioner may kindly be excluded a community land, Delhi Reserve Forest, and please to constitute a conference meeting along with landowner to resolve the matter. Now this goes on, my lord.
No, this I have gone through.
Your lordship has gone through it.
Yes.
Now this is next. Your lordship will see at page 239. 259. Please see 259. This is, we are agreed by this impugn.
No, this I have gone through.
Your lordship has seen that?
Yes.
Yes. So they said that it is forest
Yes.
real and there will not be any acquisition of said land. Now, we have given objection at page 260. Lordship got it?
Yes.
Yes. Paragraph 1, 3 and 4.
So all the notification after issuance of
Yes,
permit,
we have
you,
given objection.
It seems you are being very vigilant.
Yes.
After every notification.
Every notification.
Even you are giving a.
We given reply, objection we have given.
Yes.
Now this objection has been given to them I'll not wait most of the time because all these are objection. Now, 287, we representation to DC that please public meeting to be called for and procedure to be followed. Please look into at page 288. Please look into page 288. 5 8 5 8 2000. Please see paragraph 2, my lord. 288.
Yes.
Paragraph 2. It is 5/6/2020. 5 is the representation. Request for immediate to become a public. See paragraph 2. We have mentioned here also that you have not followed the procedure. Now, please. Now page 314 is the minutes of meeting 24th of July 2025. It is challenge. No, it is not. Now DFO what he says 2316 your lordship has seen on that day is the minutes of meeting of 24th of July
Yes.
2025. How they have addressed 316. Last paragraph, kindly see, my lord. The DFO Lohit clarified about the issue of Dalai proposed reserve forest. He said the Dalai reserve forest is proposed one without final notification, but it is as good as a reserve forest. He explained the house that any kind of development work, project under the army or any executive agency in the district is undertaken only after clearance taken from the government. An area measuring 50 square meters excluded for the user, but with no proper demarcation of any villages till date due to lack of Gram Panchayat on those days. Admitted. He also informed the House that proper government guidelines are being followed by district administration for implementation of project, as the project Frontier Highway is monitored at the highest level. He also assured full help to the public in the issue and said the solution can be brought only with cooperation. It is an admitted position by them that nothing has been done by them. He said that no, it has been done. Now, at 317, now if your lordship looks into 315, please see for a moment 315. See 315, second last. See, my lords, 315. On the top second last. See, Kare Keche of Dondi village under Lower Dibang Valley informed the house that they are welcoming the road project of Frontier Highway and also stated that there should be proper demarcation of the total area alignment of the above stretch of road. He also mentioned proposed Dalai Reserve Forest cannot be treated as final without proper survey. He described the ancestral boundary demarcation shared by so-and-so clan members near the so-and-so. All this villagers' version also has been recorded. Lordship is seeing that. They have no complaint with the project.
With this, nothing, I mean, there is
Now, my lord, these are all
representations.
Yes.
Giving.
all representation.
Then circular dated, this thing comes.
318 is the complaint.
381.
318.
389 is what?
318 is the complaint.
No, that is.
Yes. And 389 is what they have done. This is put to challenge circular. But please see this.
So this is the ultimate. They said that they had a VC in the top
Yes.
level, and during the VC they have come to a conclusion that I mean this is a reserve forest,
Yes.
and there is no land acquisition.
That cannot be considered to be excluded
So
also.
It is the final decision.
Final
that they have
decision.
taken.
And you cannot get any compensation over that.
Because it is
That
a
is-
proposed forest.
Yes.
Forest.
And accordingly, my lord,
Hmm. Now, now only the thing is that like,
this is based, this 5th of September 2025, this circular is based on 29/8/2025 at 650, 668. 668.
668.
Yes, please see that,
That
668.
that affidavit.
Yes. What does it mean? 668. Right. Okay. Oh, 666, no?
666.
666. Finally see the 666. Yes, 29th. Now see the conclusion at 66. 66, what was 667? See the conclusion, my lord.
Yes.
This is who was present. The Honorable Chief Minister was the chairman. Lordship at 29 of August 2025.
The Honorable Minister of Land Management.
No, first, we reference to the notice issued meeting under the head of chairmanship, Honorable Chief Minister of Arunachal, reviewed the construction. The meeting was attended by so and so. Now, please see at page 667.
After PowerPoint presentation.
Yes, after the PowerPoint presentation, the issue related to escrow area of so and so deliberated. A, it was decided that the concerned DC and DFO should adopt holistic approach for identification and utilization of the escrow area for the existing villages within the notified area and should desist from any land acquisition in that area. B, it was also decided in meeting that there are 17 such notified forests in the state having approximately 200 square kilometers escrow area, which should be utilized for settlement of the existing village.
No, so I mean, if you are, if you are within their excluded area, if they come to they do some kind of survey, and if it is found out that your villages are within that area of 50 square meters, which has been excluded, then you don't have any problem.
No, but the problem is that now it is too late a day because in my area that they have started.
No,
Now they cannot go back and identify that 50 square kilometers. They cannot identify. What we are saying that it is our area where we started the work, 50 square, because you have not identified. You have not identified. You
No,
have
correct. Now, if they identify and exclude,
my lord, the problem,
and they find out that you are in the excluded area, and whatever damages has been done, that they will compensate.
no, what is the problem is that entire what is my case that you have now have gone ahead with that 50 square. My area you have encroached.
How many?
Nothing remains.
How
Entire 50 square, it falls under 384 where you acquired. 389, the figure which is given, that includes 50 square kilometers. Entire, it started construction, it started all my trees, everything is uprooted. Something remains now, I don't know what it, they said that immediately it should be, if they from our side, they depend, if they go and they calculate, that's a different thing altogether. Man, what they could have done it, this exercise should have been done earlier. Not now at this stage. Now at this stage is too late a day to do the survey. Now they cannot do a survey now because they could have done it earlier. 50 my lord, if that notification, now your lordship will look into it. Propose reserve forest under section 5. Now that 50 square kilometers, what it has got a value of it? There is no question of 50 square, only if it is a reserve forest, then 50 square kilometers has to be excluded. It is till today, you have not done anything.
Correct.
Now today, suppose your lordship has said that you may not have any grievance if they identify that 50 square kilometers. But this notification of 1977, till today they have not identified. That's the whole problem.
But you have not challenged that.
Which one?
1976.
I didn't challenge. Why I didn't challenge is that why I will challenge my lord. It is their duty to identify. They did not identify entire area.
See, your problem is only with the thing is that your land has been taken away without paying compensation.
That's all only my grievance.
Correct.
Now my grievance boils down to two things. One, that whatever you have done, suppose you have taken my land also, adequate compensation has to be paid.
Correct.
This is what I am saying. If you have done it, adequate compensation. Now, apparently, one, that it is, you have not followed the procedure. Section 5 to 17. If you have not followed the procedure, what is your alternative? Alternative is that you have to acquire it.
give a
Yeah, that-
notification
that is
and
understood.
compensation
That
has
is
to be paid.
understood. Now, if it is identified that, fine, I mean, your land, your land is in the area of that 50 square kilometers, square meters or square kilometers, sorry, identified, then your land has been already taken.
Yes,
So the only thing remains, will be remaining is that.
today,
uh,
my lord, if that exercise,
Hmm.
a direction is given, 50 square to identify, they will not be able to identify. Because already they have started, that's our case. You have started. And I don't know which land they will identify. I don't know which land they will identify.
No, that obviously has
Yes.
to be a joint
Yes.
verification. There has to be a joint verification. If the joint verification is done and they found out that your land is actually excluded,
Yeah,
then,
what?
then you're liable to,
No,
if it is excluded,
what
then
they,
you are eligible for compensation.
no, what they should have done it. If section 5,
No,
up-
what I'm
no,
saying
what
is
I'm
that-
saying-
see, what I'm saying is that see 50 square kilometer or whatever the land, they have stated in their original preliminary notification that this is excluded. Let us take it, okay, that is fine. Now, if a joint verification is made and found out that 50 that they should have excluded, they have already taken, they have taken from you. Then obviously you'll be getting some compensation.
this is what I'm saying.
That's what I'm saying.
This
So-
is what,
So that's
my lord,
why-
they have used my land.
So they have used, if they find out that they have found, I mean, those 50 square kilometers, which should have been excluded, that has been also taken by them, and that is not under the reserve forest. So if they take that land, they'll have to pay
No, my lord,
compensation.
it is not a,
No, if in that case.
my lord,
Yeah.
it is not a case of now 50 square kilometers.
Hmm.
Because there are, that's what I'm saying. There are certain procedure, when you exclude also, there are certain procedure, how it is to be done.
Like, I mean, your land is more than, I mean, more than the land.
Whatever
which is-
you
which is
acquired,
included in 50 square.
no, what you said, what we said, the 384, that figure which is given, that falls under 50 square kilometer falls under that. And you could not.
384 what? What is the land measure?
Yes. The-
350, 384? Huh?
Hectare.
384 hectares. And notification, what was that? 50 what? 50 square kilometers.
No, that excluded. They are saying excluded in 1977.
50 square kilometers they have excluded.
Yes.
You are saying that 389 is your land,
What could I letter?
hectares.
Yes.
So 389 hectares is your land and 50 square kilometers was excluded. So if they come to a finding that, okay, this is correct, that your 389, I mean, hectares of land
What
is
we are,
within the 50 square.
no, what is saying,
kilometer.
384.90 is the
That is your land.
hectares to be acquired for construction
Ah.
in page 207.
Correct. Then you are saying
What
that
we are saying,
that is your land. Almost
384.90 is our land.
your land
Yeah, my land which you have already acquired.
already acquired.
Yes.
And
There is no question of any exclusion now at the
Correct.
present
no,
moment.
no, what I'm saying is that if it is excluded from the reserved area, that means that has to be acquired.
It has to be, no, this, if it is excluded,
Ah.
it is to be excluded, then there are certain procedure to be followed, to be excluded.
Now,
Assam Forest Regulation,
that I understood. That's the process.
yes.
No, I mean, I just wanted to understand is that if 50 square kilometer is excluded and your land falls within the 50 square kilometer,
Yes,
that means they cannot take away your land just like that.
Yes.
They'll have to take your land by land acquisition only.
correct, right, that's my
And
case.
in that situation, you'll have to be paid.
Yes,
certain
that's
amount.
our case.
Correct.
Yeah,
Now you are saying that there is no demarcation
yes,
happened. So they are also not sure whether your land falls within the 50 square kilometer or not. If it is found out that your land falls within the 50 square kilometer, there is an exercise carried
Yes.
out by them and it falls under you and that has already been taken by them.
Yes.
Then obviously you'll have to pay.
That's
pay
what
some
I'm saying.
compensation.
that today,
So if they carry out an exercise now.
no, what I am saying, that today also they can also, exercise can be carried out by stopping the work. You stop the work and carry out the exercise.
That is what I'm.
Stop the work, you carry the exercise.
That's what I'm asking.
No, you
So-
can stop the work and carry out the exercise.
If they stop the work and carry out the exercise, then they come to a conclusion, okay, this is fine, that it is not within 15 square kilometer. I mean, it is within the 15 square kilometer. inside that 15 square kilometer area. That means like that
Now what will
that is
happen?
not reserved area.
No.
And that indirectly means that you'll have to be given compensation.
No, what they have done is. But you see, my lord, the problem here is, if you see for a moment, please give me some moment of the Assam Forest Regulation Act. See the Assam Forest Regulation Act. So, you ask me, go to. See the Assam Forest Regulation Act.
No, your concern is compensation.
No,
And your concern is that your land has been taken away and you need compensation for that. That is your case.
Well, only one thing, where is the question of demarcation, 50 square kilometer, how they will demarcate?
No, because you have not challenged that 77 as yet.
No, I have not challenged it.
So you have not challenged it. So that means the 77 stays in your case at least. Till now it stays. You have not challenged it. So if it is stays, then there is a statement there saying that 50 square kilometers will be excluded.
Yes.
If you take it as it is, then now you are saying that your land is within that 15 square kilometer.
Yes.
Fine, perfectly fine. So
Yes.
if your land falls within 50 square kilometer,
Huh.
that means your land is not proposed reserve forest land. That
Yes.
means your land has to be acquired.
Yes.
So now they, without acquiring your land, without paying you anything, they have utilized the land. So they are liable to pay you. That is your case.
No, but that is my case.
Hmm.
But what I am saying, the entire thing will go. It is not, my case is that, the compensation has to be paid. My lord, the entire process which they have done, entire process, the illegal process which they have done it.
No, that I
Am I clear, my lord, what I am saying? Because I am challenging 4/7/2025. I am challenging 5 as a whole. As a whole, I am challenging it. What I am saying that section 5, proposed reserve forest, it is a meaningless, just it will remain like that. It becomes a forest land for us.
No, Mr. Das, I understood that. But this is not a PIL.
Not a PIL.
You are not filing a PIL.
No, I am not filing a PIL.
So now your concern is only with the land that has been utilized by them without paying you any money. Correct.
But what they
Now,
could have,
if
I have understood what your lordship is saying. But when section 5 has been issued by them, please look into it. What is the purpose of using section 5 and what steps they have to be taken? Please look into it.
Those admittedly
No, they have not taken any steps. Now they cannot go back and say, kindly see, my lord. Please see that 5 is a notification. 6 is proclamation by forest settlement officer.
Yes.
Now 6D, fixing a period not less than 3 months from date of publication and requiring every person claiming any right or making any claim referred to or mentioned in section 5, either to present to such officer within such period a written notice specifying or appear before him within such period and state the nature of such right or claim. Lordship got it?
Yes, yes.
Now,
But these are not, admittedly they have not followed it.
no, what they can do it, like my lord, my submission before this court at this stage, my lord, if they want, they can survey it. But they will not continue with the work. The continuance of the work will make a lot of problem with us. Not a problem, my lord. Because these, how a calculation can be made if everything is over? Let them say what is the status, and my learned friend has pointed out before the court that day, status is that work is going on full swing.
That will not help.
Work is going on.
That will not help.
The best thing, why they doesn't, my lord, joint? NSCDCL will also remain with the consent of all the 3 parties that they will stop the work. In the meantime, they will survey it and they will say, they will look into it.
NHIDCL, what are you doing?
Work is going on.
No, work is going on fine. I mean, thing is that there is an issue involved. I mean, you should also actively participate in this issue to resolve. And what is your, what you are doing on that? Your affidavit doesn't say anything. You are just putting this, I mean, all the things to the state government. Isn't it?
Yeah.
Hmm?
I asked
And
the,
HIDCL is also a state corporation. It's a state concern. So you should also actively, should have been actively doing something to resolve this issue.
but if there is a consent of all the parties, I think there will be no problem for the court also, consent for the parties, all the party consent.
Hmm.
I think my learned friend
Yes,
both will
about
not
what
agree,
is to
disagree
be
with.
done, you tell me.
Yes, sure.
There has to be, see, there is, I mean, there, it is admittedly that their land has been used,
Yes, sure.
right? And in that regard, they have brought in not many materials to show that they belong to those villages.
Yes,
So there is no dispute about that.
Yes.
They belong to that village, those villages. And there is no dispute also what I can see from the materials that, I mean, the road is being built there and their land has been used, right?
Yes, sure.
So in this now, the thing is that like, only thing is that like their land has been used and like they have not been paid. And your notification is not there. Admittedly, your final notification is not there.
Yes, sure.
Only that, I mean,
77
that preliminary notification is there, and which that doesn't have any value if you do not have a final notification as per these rules. Because issuing preliminary notification doesn't give you the right, the whole right, I mean, take away somebody's land.
Yes, sure.
I mean, you'll have to give a final notification, you'll have to do hearings with the villagers who are settling there. Then only you can pass a final notification.
Yes.
That you have not done.
Yes, sure.
So that means the land, I mean, land has not been declared as reserve forest as yet.
Yes, sure.
Now you have taken their land. The only thing is that 50 square kilometer was excluded.
Yes.
Now you have not done that exercise of demarcation also. Now what is the solution? What do you want to do?
Your Lordship, like my senior said, a joint verification must be done
But that work has to be stopped.
for a very short time period, Your Lordship, so that it will not hamper the work.
Short time period means what? How much time?
At least a weeks or 10 days, Your Lordship. We'll try to verify this.
But verify not alone, verify
Yes,
with the
yes.
clan members, with NHDCL, with government, and in the meantime,
All the stakeholders, including NSIDC,
everyone will be
Forest
present.
department, your administrative functionaries,
Yes, sure.
everybody has to come together, then do a joint verification, find out,
Yes, sure.
then you submit a report.
Yes, sure.
Clan members, 10 days, I think it will be not possible. Because they have to give notice to, and I will inform my parties, that will be easier. Inform the parties, so they doesn't have to give a notice also. Inform the parties,
Now the work is going on, right?
work is going on.
Work is going on.
Yes, yes, my learned friend also.
Full-fledged.
Yes, yes.
Full- I think they will be the person to answer that, Your Lordship.
Are you agreeable to this?
There, I told them also that,
So I mean, so we'll do one thing.
but I spoke with additional advocate general also.
Mm.
My learned friend, what he said, he argued that matter said that his all procedures are not being followed. It becomes illegal. I spoke to Ratan also. He said, sir, I have done that case of 2025, he was appearing. For Rikar, I think he was appearing. Yeah, I told him that this is a situation. See, now these are situation mean these are all illegal.
So we'll do one thing, we'll ask.
But can I just suggest, I have asked my client also, it can be surveyed and they can, if they are surveyed, and what is a jirat also? That yes, that your lordship can spell it out. Survey and they can,
I think 4 weeks time is sufficient.
I think enough, 4 weeks. 4 weeks.
4 weeks time, we'll have to stop the work and do the survey and submit a report before this court.
Yes.
What is that?
Yeah, I think that's also, I thought they submit a report.
They'll have to submit a report
Yes.
before this court. And what is the status of the land?
Mhm.
What is the status of the land?
Mhm.
What is there in the report you submit?
Yes, sure.
And after submission of the report, the matter will be heard. You know, whatever.
Correct, right.
Matter will be heard. So I don't think we need to go into, I mean, many other things now.
Yes.
Uh,
And
if
I don't want also, my land friend, that if this they find that after giving a report also, now tomorrow on merit, if it is heard, and saying that they could not have and then it'll go. Better they take another option by making, I will not say too much of it.
This court doesn't want to comment on, but I mean, some proactive steps should have been taken to avoid all these things.
And we have taken all steps. And we also said that this
Those are
advice.
your own people only. If there are some, some fake claims,
That they
that is a very different thing.
Well, that
Yes,
has to be,
that-
that
that
has
will
to
be-
be identified. No one will give it, it is to be identified. These are the clan members. Number one, whether they are in that village or not. We want to see. Then this will be identified. Accordingly, it will be paid to the actual beneficiary, not to those fake person members.
So you'll have to, verify all these things. You have to do a survey, land survey. You have to find out which land, where they are staying, how much land has been taken.
Yes.
Then, whatever things that you have already destroyed there, Gerard thing. If there are some, crops were there are some,
In a way, yes.
some assets were there.
Detailed survey also.
If those have been destroyed, then some survey you'll have to do.
Yes.
So you'll have to work on a work foot basis because it's not very easy to job to finish in 1 month also. So you'll have to do it.
Indeed, Your Lordship, but we will try, Your Lordship, at our best.
What to do. So I will pass an order saying that in agreement between the
Yes, yes.
amongst the parties,
Yes, Your Lordship.
and a survey.
Consent only by the conscious.
Till the time you, that's what.
Uh.
Till the time, you submit the report.
Yes.
So the work should not be.
Status and they will calculate.
Status quo will be maintained till the submit
Status,
report.
they will not proceed, my lord. Otherwise, status quo is an
it-
order which is very difficult. They are very difficult.
So
You can
now
interpret this way, that way
now
also.
status is the work is going on.
Yes.
Status quo also work.
What will go on? That's the whole difficulty, sir.
Okay.
I remember status quo order in circulating at T-State. The court has passed the order, many people died, my lord. There are a lot of firing incident which has taken place.
The status quo word is little bit, it's a relative word.
Yes.
So it's a little bit difficult. But anyways, I think we will give them one month's time
Yes.
to do the survey. Survey, what do you say? There's a survey, what kind of survey has to be?
Survey, the land survey.
Land survey, they
Yes.
will verify whether you people are there or not,
Yes.
and how much land has been taken,
Yes, correct.
utilized
Yes.
for the project.
Project,
That
yes.
you do.
And whatever,
And
the
whatever, you
calculation
destroyed,
of Jurat, they will also
whatever you
decide.
have destroyed or the
And the
assets,
calculation of assets
They
which are still there, they will calculate,
that has to be calculated.
Yes, Your
calculate.
Based on this.
This is section 29, your lordship, of the Lara Act,
So then,
In accordance with the 2013.
2013.
Russell, I think. Okay, then I will conclude it and I'll pass the order as soon
Yes, yes.
as soon as possible. Heard Mr. D. Das, Learned Counsel, Learned Senior Counsel, assisted by. I have already passed the order. No? Oh no, that's it.
That's nice. I does and Mr.
Mr. So and so.
And Mr.
Right.
Khalid is there.
You take all the names. Mr. Khalid also. Then you write order reserved.
Yes.
Hearing on interim relief is concluded. Order reserved.
Obliged, Your Lordship.
I'm deeply obliged.